Okay, it's David versus Goliath call. Time to get started. Courtroom procedures, recordings on the record. Tonight we got a special guest by the name of Richard Mendez. Richard, take it away.
Good
Jackie
evening.
Fig.
Yeah. Welcome to David versus Goliath. This is a entity that was developed by Jackie Fig and myself a little over about 2 years ago. But since then, Jackie Fig has since passed away in an airplane crash. But one of the things we wanted to do was bring to the public most of the pro se litigants that didn't really understand about courtroom procedures. A lot of times people, what they do is they do their paperwork, give it to an attorney. The attorney goes into the courtroom and represents their paperwork before the court. And they basically leave their lives in the hands of the attorney. If the attorneys don't know the paperwork quite well or don't know the case good enough and are misrepresenting material facts before the courtroom, then, oh, well, you end up losing your case. But here with David versus Goliath, we're hoping to make you a gladiator. We're giving you all the procedures, and also we're giving you guidance and objections, evidence, what's admissible evidence, the evidence codes, the objection codes. You know, like let's just take one for instance. When you walk into the courtroom, you should always know and ask first if there's a court reporter before the courtroom, because if you don't have a court reporter, everything that's been said before the courtroom falls on deaf ears. It's nothing but hearsay. It's called inadmissible hearsay in an appellate courtroom. So you always want to make sure that you have a court reporter. You either ask them to see if they're recording. If not, then what you do is you have to hire your own court reporter. But I always tell people that what you should do is call the court, find out what courtroom you're going to be in, what judge you're going to be in front of, and ask to see if they record the hearings. If they don't, then what you want to do is you want to find out. You can ask the court and they can give you a list of court reporters. But if not, you can always find a court reporter listing, searching on the internet for the areas, and you can hire that person to come in there for your hearing. But what we say is that you need to be prepared before you walk into the courtroom, because you have to understand what is admissible or inadmissible hearsay. And when I say hearsay, that's testimony of a person that's given information that he has no firsthand personal knowledge of. He's heard it from somebody else, like an attorney. Let's take an attorney, for instance. An attorney who represents his client, usually for the other side, he got his information from his client. So what he does is when he got that information from his client, that when he's in court, he expresses that information. That's what we call secondhand information. That's considered hearsay because he heard it from somebody else. So now he's saying it. So it's not on firsthand personal knowledge. And then if the person who gives that information, like the attorney, if he don't swear in under California Evidence Code 702, I'm sorry, California Evidence Code 710, which is required. That is required for anybody that's going to testify before the court. He has to swear under 710, because any testimony that he gives can be objected to as being hearsay. So for it to be admissible, he has to swear in. Now, you can object to that person under 702. Okay, you can object to him for lack of firsthand personal knowledge. And once you make that objection, then he has to show his firsthand personal knowledge before he can testify before the courtroom. Okay. Now, those are some of the things that we work on here in David versus Goliath, you know, to make you a gladiator. We also teach you or guide you, let's put it this way. We guide you with objections, when to object, because an objection not raised is an objection waived. Okay, you always have to remember that. We also work with the California Evidence Code. We work with California Civil Code. We also work with CCP. We also work with California Court Rules. We also work and look at the judges, California Judges Bench Guide. We also look at the judges' judicial canons, because when a judge comes into the courtroom, he has to have, he can't be arrogant. He has to be very polite, very courteous to you. Okay, when you're in court, they're public servants. So when they express something to you, they have to do it in a very diplomatic way. They can't be very arrogant, angry. They can't subject you to yelling or what would you say, making lewd remarks or discrimination, things like that. They can't do that. They're supposed to be They're not supposed to be biased or prejudiced toward you. They're supposed to be a neutral body. that
Oh,
weighs-
but they don't.
Absolutely. So basically, what we do is we guide you along these ways to show you how a courtroom works, because it's like playing any other game. Whenever you want to play a game and you want to win, whether it be poker, whether it be chess, whether it be dice, whether it be golf, if you want to win, you begin to learn the rules, the ins and outs of everything. And it's the same way when you come into court. You need to learn their procedures, because you have to understand, if you're involved in litigation, and let's take the non-just foreclosure. If you come into an unlawful detainer courtroom and you're a prior owner of the property and your property was sold at a trustee sale, then they have to bring an action pursuant to 1161A B3. And you really need to understand these statutes, because here in the state of California, the non-judicial foreclosure is a creature statute dealing with real properties and deeds of trust. So that meant that anybody that's trying to take your property has to make sure 100% that they comply and follow the strict mandatory statutory scheme from 2924 and all to be able to get to 1161AB3. But you probably won't understand a lot about this right now. But if you come into our class, you come work with us, there's a lot of questions that you can ask, and I'm pretty sure that you're going to find a lot of answers here. Whereas like me and many other people, we've gone to these other so-called gurus out there, and everything sounds wonderful, but when you leave there, you didn't know any more than when you came there. And you come out there and you try to apply that in these courts, you're going to find out that these courts don't work that way. What we do is we give you the actual mechanism that these courts work with. We work with you on the case law that they use, that is controlling case law. We call them stare decisis, cases that have already been decided. These cases have already been decided in the appellate courts and the Court of Appeals and in the Supreme Court. Okay, and the way that it works is when you're in a lower court, let's take an unlawful detainer court. It's called a limited jurisdiction. When you're in that court cannot reinterpret the law. It's already been established by an appellate division, Court of Appeals, and then you got the Supreme Court. Now, if you got a Supreme Court decision over and you bring it before the courtroom, that court has to abide by that Supreme Court decision, because it's already been decided by them. Okay. Now you've had cases that have been pulled up into the appellate court, and in those appellate court decisions, what happens is they've got Court of Appeals that might have already been overturned, or they might have tried it another way, and now the Court of Appeals is controlling. Okay. So that's why you always have to look and find out what court case is controlling. Okay. And those things will help guide you along too. So we would welcome anybody that wants to come to this court, to David versus Goliath and become a gladiator like us. Is there anything else anybody wants to say? Like Gavin, you anything you want to talk about, or?
Well, would it be good, when I walk into a courtroom against one example here is I walk into the courtroom up there in Yolo County, and I got put into the presiding judge's courtroom, and I had an attorney over there on the other side, but I forgot to bring a court reporter into the courtroom. And I didn't really know what to do. So when I went in there and I said, hey, good morning, Your Honor, I'm going to object to the attorney testifying here on the other side under evidence code 702, as he lacks personal knowledge under evidence code 710, he's failed to swear in. I'm going to object to complaint being used as evidence under 1401A the evidence code, because it lacks authentication. He forgot to bring a real party of interest with him. But before you raise those objections, Your Honor, I have a question. Does this court abide by the California best evidence rules? And then the judge says,
Go ahead.
Is that a good question to ask him? Because he
Well,
says, well, I don't have to
you
answer
can.
that, he says.
Yeah, you can, and right now Gavin's raised some pretty good evidence code that you really need to understand. See, 1401 and A and B of the evidence code. You look up California evidence code 1401 and you're going to find A and B. And A says authentication of a writing is required before it can be received in evidence. So if you don't object when an attorney or the plaintiff submits a document, a written document before the court, you don't object to it, it can become factual. It can become evidence against you in support of its what we call preliminary facts. So what we need to do is we need to look at that and say, okay, I want to object to that, because it's not authenticated. Who authenticated that document? Now, an attorney, see, that's been hired by a plaintiff, they do what they call verification on a complaint, which we challenge and dispute. And when you come in our class, we'll begin to break that down for you, so that you can really understand that. But the other one was 702 and 710. See, anybody that's going to testify, not just only an attorney, but anybody that's going to be testified before the court has to be sworn in under 710. But see, the courts have become so lax over the last, I'd say maybe 25, 30, 50 years. They've become so lax, they let anybody just talk in the courtroom. And without your knowledge of how the court's supposed to work, you will allow them to go ahead and continue to talk. And you might say, well, no, that's not true, this, that, and the other. But you let him testify on something, and you're going to sit there and argue against it when really you should have just objected to it. You should have objected to him testifying because he has no first-hand personal knowledge. And so what you do is, if he doesn't have first-hand person and he didn't swear in, you're going to move to strike the testimony they just made. When you say move to strike, that means that testimony cannot be used by the judge to make a determination in the courtroom.
Yeah,
Okay?
for example, the attorney in my case, he says this, but I want to see it. Let's say I was the attorney. And he says, yeah, Your Honor, we're here for my motion for summary judgment that I'm bringing against the defendant over there, Mr. Mail, he failed to make his mortgage payments. He got behind on all his payments, and then the bank took his house back, on a foreclosure. And, he's failed to bring any evidence forward in his case to raise a defense about this case. So I'm going to ask the court to issue judgment in favor of my client, who's not here today, but my client is a matter of law. Is that proper?
Yeah, you can state.
Well,
things like that.
that's what the attorney says. So I'm
Oh,
saying, is
the
he allowed
attorney,
to say all
no,
that?
the attorney can't, the attorney cannot make testimony, in the courtroom. Well, he can if you don't object. That's the issue.
So he says he didn't make his mortgage payments and he got behind on all his debt. Is that a proper? Is he allowed to say that?
No, he can if you don't object. See, the attorney can say, well, he failed to make his mortgage, he's defaulted on his loan, and therefore he's a deadbeat, Your Honor. He's and my client bought it at a trustee sale. See, this is what happens. That's what the attorneys get in there and state like that. And they don't really have a right to do that, but they do it because we don't understand the rules of engagement. And once you don't understand the rules of engagement, when you walk into these courtrooms, they're going to do whatever they want to do. But see, when you begin to understand that, that's when you can stand on your own 2 feet and you can make your objections. And if you don't want to go on by yourself, then what we do is you'll begin to learn and understand that if you have an attorney that goes and represents you before the courtroom, then what you can do is you can say, Your Honor, may I have 15 minutes with my counsel because I'm led to believe that he failed to make an objection on an issue that I believe that he should have objected to. Now, see, that helps the attorney now. That don't put the attorney in bad light of the court, and the court can say, well, Your Honor, I just spoke with my client, and yes, he conferred with me, and he wants me to make an objection on. I believe that we should object on that issue. Okay, so now you can object that, move to strike it. Okay, and that's what your attorney would do. Knowing these things, all these little elements and these little nuances within inside the court that goes on in the court will help you in your case, because a lot of times you're going to know the case far better than them. You're going to know every nuance, every nook and cranny, every in and out of your case once you read it. And maybe you might not, but in here we'll help guide you. Here's a platform where you'll begin to get some kind of understanding. You'll get some kind of comfortability. You'll walk away knowing that you have knowledge. Knowledge is power if used the right way. Okay, so that's what I always tell people. I says, because if you can have knowledge about a lot of this stuff, but if you don't know how to apply it, and that's when you walk into the courtroom. Use courtroom etiquette inside the courtroom. The court's like that. If the court knows that you really know something and you proceed correctly, some of the judges really admire that. And the reason why they don't like pro se litigants a lot of times is because the pro se waste a lot of the court's time. The court will ask you a question and you'll start talking about your grandmother and your kids or your uncles and this, that, and the other. He says, no, I'm talking about this. Yeah, but that has to do with this because of this. No, he's asked you a specific question. You have to respond specifically. And if you can't, you say, well, Your Honor, I said that's going to be a very difficult response because I can't answer with a yes or no. I need to give you a little bit more background or information on that to help the court be able to see it in a better light or to understand it better. See, that's what you have to do. You have to express it to them like that. The other way would be is when you walk into a courtroom, you should always remember courtroom etiquette. There's two ways. Well, there's many ways, I should say. They're not just two ways, but when I look at it, there's two really ways to begin with that you can do. And that is, what you have to do is you have to, when you walk into the courtroom, you basically say, "Good morning, Your Honor. My name is so-and-so. I'm the defendant in the matter." And if you're the one that filed the documents, then what you're considered is the moving party. You're the moving party of the action. And then what you do is you basically say, "Well, Your Honor, I said, yeah, I'm the moving party. I filed a motion and my motion to strike, my demurrer motion to strike. And also I did a request for judicial notice. Has the court had the opportunity to review all of those documents, Your Honor?" And he'll say yes. I said, "Well, there's one in particular, Your Honor, I'd like to direct the court's attention to." And that's what you're going to do. You want to have them direct the court's attention to whatever it is specifically that you believe 100% will help you in that case. Okay. And once you get in here, you'll have case law that supports your contention. Whether you're a defendant in a property where the owner lived or didn't live. If the owner doesn't live with the property, you stand a strong chance of staying in that property until your lease agreement's over. That's pertaining to the Homeowners Bill of Rights. But Obama's Protect the Tenant Foreclosure Act back in 2009. The Homeowners Bill of Rights was in 2012 by legislation, enacted by legislation and signed into law in 2013, January 1, by Jerry Brown. Okay. And that amended some of the statutes and requirements before they could initiate a foreclosure, on a property. And to initiate a foreclosure on a property, you have to comply with the strict statutory requirements of 2924 and all. That means that under 2924A6, you have to be the holder of the beneficial interest. So see, there's a lot for us to know as we go forward on this issue. So we would welcome you to come forward and start working with us, become a gladiator, start training with us, spread the word, help other people, each one teach one mind at
Richard,
a time,
How was it that you got started in this? Did you first get trained in martial arts?
Well, yeah, back in 1974, I met Bruce Lee's wife, Linda Lee. That's how I got involved with that. And I really became really super involved in that, like I am in this now. And I think because of what I did in that training in that art, it helped me cross over in this one here, because I hate to lose. And so, in training in martial arts and that, you really have to train a lot. You have to eat, sleep, drink, think, be that every single day. You have to work on all your elements, your tools, not just your cardiovascular, but you have to work on your timing, rhythm, your muscles, your plyometrics, your fast twitch muscles, your awareness, your quick eye seeing, things like this to improve yourself, And then I transcend that into this one here. So I began to look at things. I said, well, our adversary, who's our adversary in the courtroom? Well, I found out when I went into the courtrooms, it was not only just the plaintiff, I found it was the judge. See, the judges in there were basically becoming the adversary. It would be just like fighting Muhammad Ali, and all of a sudden you're beating up Muhammad Ali really good. You're beating him up against the rope, smacking him, and all of a sudden somebody starts hitting you from behind. And all of a sudden you turn around, and it's the referee, he's hitting you. He can't do that. So this is what's happening in the courtroom. You're over there beating up the attorney, and all of a sudden the judge jumps in and starts saying this, overrule this, starts asking questions and stuff. But he's a neutral body. That's why you have the statute, what's called blind justice. He's sitting there blindly listening to all your testimony, admissible testimony, and your evidence being submitted before the courtroom, and he's supposed to weigh it. Whoever presents the best case, base case law, base evidence, and the best testimony, and before the courtroom is the one that should win. It's not like he said, well, wait a second, I just got this. I'm going to go back in the back room and then I come back out, and all of a sudden you see case law that you didn't put there. You see case law that he didn't put there, but the court put the case law and says, well, you know what? You did a good job, but this case I found out right now kicks your butt for him. So I'm going to give it to him. And that's what happens on 90% of the time, because we allow it. We didn't understand the game. I don't have no problem with you taking it under submission. as long as you don't add anything to it, you don't add any other case law to support him. Yeah, nobody ever talked to him like that. Nobody ever asked questions or made
Are you
statements
saying
like
that the court's isn't supposed to bring up a bunch of new case law inside the
thing
pleadings
is
that
like
wasn't brought up?
this. Yeah, because they're not allowed to, they're not supposed to do certain things, which a lot of certain things. And that is they're, but they do it all the time. They call it an abuse of discretion. But, that discretion isn't allowed. This discretion is only allowed when you're ignorant, when you don't know the rules of engagement, when you don't understand how to present your case or what case law controls and things like that. They were never there to be able to say, wait a second, sir, you raised a good deal here, but I got a case right here that can just kick you up and down the street. And counsel, don't worry about it. I got your back. I got your back over here. Don't worry. I know that this guy's pretty sharp, but he ain't as sharp as us. I got my law clerks and stuff in the back. And we came up with this. That's just amazing to me that they would do things like that. That's not how the court. You were supposed to go there to the court and have an administrator sit there and listen to you, and your adversary was supposed to fight. It wasn't like supposed to be you and the adversary and the judge. It's supposed to be you and the adversary, and that was it. But they've taken it out of the equation, and you were taught and bred to believe, you were indoctrinated that you had to be like that, and that's not how it is. Well, it is now because we've allowed them for so long, and now you're going to go and you're going to try to change them. You're going to go and try to change these guys. And the first time you start knowing what's going on, he's going to,
What about in the case here, give an example, I go into court and I don't recognize the attorney on the other side, and I go in, it looks like, I've seen him out in the hallway. He was actually on the case right before mine, and the case before that, he keeps going up on the case one after another, and I don't recognize him. So when I go to court, would it be proper to ask who he is, who that attorney is? Is he the attorney of record, or is he by special appearance? And
absolutely, you should always ask who it is, because everybody that goes before the court, and this is one of the things I began to look at right now, because it's just like on a chess game. When you got a chess game, you need to know who the pieces are and what they're doing. Like when you play chess, a lot of people that have played it, you got a king and a queen, you got a rook and a bishop and a knight and a castle. So. And each one of them have a movement that you got your pawns. Each one of them have a certain movement that they can make. You can't take the knight and go in a straight line. It can go in an L shape. You can't take a bishop it can go diagonally in one way, but it can't go up in another color. It cannot go that way. So, and a castle can go straight lines back and forth, but the king and the queen, they can do anything that they wanted to. The only difference is the king can only go do one step at a time, whereas the queen, she can move any way she wants to. So I figured, well, gee, if that's the way that the game is, when we walk into this courtroom, who is an attorney? What can he do and what can he not do? Is he a special appearance attorney, or is he the attorney of record? And then if he filed the documents with the court, is he the one that filed them? Is he the one that verified them? Okay, and remember, if you hire an attorney and you're not before the court, he got all his information from you. So when he walks into the courtroom, he's going to talk about what he heard from you. So what does that become? Hearsay, inadmissible hearsay. And so now if you got a special appearance attorney coming in for that one, they have requirements they have to meet too under CCP 283, 284, and 285. If an attorney comes in, a special appearance attorney comes in, he has to give notice. The special appearance for the plaintiff in behalf of the other attorney of record. They never do that. Never. You don't see them file a SIP 150, which our special appearance attorney does all the time. He doesn't do that. They don't do it at all, and they're supposed to. There's a lot more to this than meets the eye, but that's just the logistics, just a small amount. So if you really want to learn and grow, come with us. Come to David versus Goliath.
So this is all about courtroom procedures. And I know some of the questions that people have about maybe filing another action in another case or going in another court. And that's good too. But is it as simple as going into court and controlling the court. Could it really be that simple?
It is in a sense, it is, but it isn't, it isn't. And the reason why I'm saying it is because once you understand how the courts function and you understand the rules of engagement, you understand their codes, evidence code, thing like that, then you can talk through it. When you don't, then it's not going to be. And the other way is, even when you know, though, sometimes they're going to become uptight because you're going into somebody's, it's their house, their court. What are they going to do? They're going to tell you, well, this is my house. These are my rules. And that's how they can act. But as long as you got a court reporter there and you know the rules of engagement and you got them down, then when they make errors in admission, you can take them up on a writ of prohibition, take them up to Court of Appeals. You know?
So a few years back, I remember there was a case that a lady went into court and she trained over and over again. And all she did is she got sued for unlawful detainer. I don't remember her name, but she got sued for unlawful detainer. And she went into court and objected to the attorney testifying, objected to the complaint being used as evidence, objected to the real party of interest. And she stood on her square with that. Do you remember that one?
Yes, absolutely. She walked in the
What happened in
courtroom,
that
she
case?
basically stated that she said, "Good morning, Your Honor. My name is so-and-so. I'm the defendant in the matter." And she said, "Are we going to swear in?" He said, "Yeah, okay." And because she asked him if the matter was being recorded, he said, "Yes, it is." So she swore in. And after that, she said, "Your Honor, before we begin, I'm going to object to the attorney testifying under 702, lack of firsthand personal knowledge. Plus, I'm going to object to the complaint that he's filed here under 1401 A and B of the evidence code." Okay. And is the party that the real party of interest here before the court? And he said, "No." And so the court just turned to her and said, "Okay, case dismissed." And the attorney got uptight and jumped up and said, "What do you mean dismissed?" He said, "Well, you have no evidence before the courtroom." See, the complaint is evidence. It's called preliminary facts. They're all preliminary, and they become factual when somebody testifies to the validity of them on firsthand personal knowledge. Remember, all non-just foreclosure with creature statutes dealing with real property and deeds of trust. The deed of trust is the foundational document they use to be able to go against you. But see, the thing is, I can only use the deed of trust if I am the holder of the beneficial interest. If I make documents to make it appear like I am the holder, that's no good. But if you don't rebut it, challenge it, dispute it, object it, do your investigation on it, it becomes facts before the courtroom, and the court relies on that.
So are you saying that the attorney brought the complaint in and she came forward as a defendant? He had a complaint and a big stack of paperwork in, and he says, "Your Honor, I'd like to move this complaint and exhibits into evidence." And then she said, "Wait a second. I'm going to raise these objections."
Yes.
And then because she had a court reporter there, the matter was on the record, and you're saying that she won the case at that one hearing. Did she have to file a bunch of motions and be an expert, motion pleader and all that? Did she have to do all that?
Nope. She was very nervous, very, very, very nervous, but she practiced for like 2-3 weeks. And when she went in there, she said, "Rich, I was shaking at first, but after that," he said, "when I saw how nervous the attorney was, I was happy."
So did she have to file a new lawsuit and file a civil case and file all these other things? Did she have to do all that?
They'd have to file it again. They'd have to come
I
back.
mean, but did she as a defendant have to go and file another lawsuit and do all these other motions or any of the appeals or any of that? Or did she just go into court and talk?
No, she just went in the courtroom and talked, and that was it, and won the case. But the thing is, because if you go in a courtroom like that, you have to be prepared 100%. This girl prepared herself like you wouldn't believe. I mean, she rehearsed it 1,000, maybe 5,000 times. And so not only that is that, they will come back if you get the case dismissed, and they're going to do it without prejudice. If you can get the case dismissed with prejudice, then you can take that and have it recorded in the county recorder's office and then submit it to everybody. There's things to do, a lot of different things for us to do. So, but that in a nutshell, that's what it is, for right now. There's many other things that we need to get into and talk about.
If anybody has any questions, feel free to raise your hand.
JD.
Okay, unmute. Okay, JD, go ahead.
Yeah, thank you very much. That was really very informative. Appreciate that. You mentioned that you should object to the attorney speaking. How about when the paperwork comes in and you get attorney making declarations on paper? How would you go about filing like an objection or some sort of
Yeah,
same
because
process?
see, no document by itself can stand, even when the attorney makes a declaration, his declaration, if he's made the declaration, you can object to him on, because he has no firsthand personal knowledge. And you can, underneath the evidence rule, when an attorney makes a declaration underneath the evidence rule on 1200, it's inadmissible hearsay.
So how would you would just go about it the same way on paper?
Yes,
just
what
like
you
that?
do is you're going to object. Yeah, you're going to object to this, but you can pick the statements in there. It says you're going to object to this as being hearsay, lacks foundation. Object to this and hearsay, lacks foundation. Object to this statement. Object to hearsay, lacks foundation. And then at the end, just the defendant objects to the entire declaration by the attorney because it's hearsay, lacks foundation. And then
I also put a document there in the chat room that goes through about 15 different objections and their basis, lacks foundation, hearsay, testifying, there's like 15 different ones. So you have to really look at what's said and then identify, which one applies.
See, there's
Okay,
so much that you won't know in here because even the judges will basically, like counsel, are you going to be filing a demur? Are you going to be filing this? Are you going to be filing that? Objection, Your Honor. Are you giving legal advice to the plaintiff's attorney? No. I said, well, yeah, you are. You're leading them. You're
And
giving
it's
them advice.
All the stuff, if you just go into the chat room, it's under right in there. There's a link in there. Anybody can download that. It has all the main objections and the main. So sorry, Richard, go ahead.
No, but that's okay. But any other questions?
It's a complicated answer, so it has all the
Any other questions, comments, hate mail, love letters? See, pretty much, JD, a lot of the people on here already have heard this stuff quite a few times already. And they're probably sleeping right now. They're like, if we open up all the comments, you'd be hearing a lot of snoring and crickets.
no.
Yeah.
My only comment is thank you once again for a really good meeting.
Thank you very much, Tina.
Same here.
Yeah, you'll hear it 1,000 times, but I hear it to myself 1,000 and maybe more. Because when you go into these courts, you have to be well prepared and you have to understand the statutory scheme. And you have to understand why you're going in there. What is your fight? It's fight for your life and your property. And did they have a right to be able to take your property? Because the code tells you they can do all these things. Supreme Court cases, appellate decisions. We have, that you really need to look at McLeodis versus U.S. Financial or U.S. Financial versus McLeodis. In that case, it tells you have to duly perfect the sale before you can duly perfect the title. You have to duly perfect the sale before you can duly perfect the sale. And that means that when you make a statement like that, what does it mean? I just have to record one document and then I duly perfect the sale. I'm entitled. They hold the sale, and so they duly perfect the title. It was they complied with when they did 2923.5, 2924.F7, 2924.7 or 2932.5. Did they comply with all those statutory schemes? No, they don't even show that. They don't even talk about that. But you have to be able to go in there prepared to be able to show them. We got great cases. We got Kessler versus Bridge. We got U.S. Financial versus McLeodis. We got Seriata. We've got there's that new one what's that Finney something. I'm going to think of that name. Finney Francis Deutsche Bank, something like that. Nativity versus Deutsche Bank, which is really a fantastic case. And we have Fontenot versus Wells Fargo, Deutsche Bank. We got oh, let's see. Preciado, we have Preciado versus that. We have Dr. Levo versus Westlake, which is a Supreme Court case ruling. All these cases support our contention, and each one of them have a phrase or some dialogue in there that will help you. And when you're going to express it, and when they say, no, this is just a summary proceeding, it's about possession. No, it's not. I said it's already been determined in these courts. Remember, it says when it's between a landlord and a tenant, then it's about possession. But when it's a homeowner purchaser, then title's not to lie, meaning that you have the right to be able to challenge that. And then in Kessler versus Bridge, they stated that if the defendant had the right to be able to challenge the voidness of a lease agreement or a contract, then that would not preclude a homeowner from challenging a void document. These guys, they've really pulled the wool over a lot of people's eyes, and people are not really coming here and educated. They really need to educate some of these judges on this issue, when you walk inside there. And when you say that the non-foreclosure is a creature of statute, there's case law that you put, that's Pro Values versus Quality Loan, that's Kessler versus Brad. They have those cases that will support your contention, So let's get it done. Welcome to David versus Goliath. Become a gladiator, And any other comments, questions? JD, any other questions, comments?
Oh, I got so many. I hate to,
Yeah.
You okay with it? I could ask about the when you talk about citing case law, as a pro se a litigant, is that something that we need to be responsible to know and to produce?
Yes, always. If you're going to go there, if you're going to go fight in the ring, is it your responsibility to learn how to fight and punch and kick and do that stuff? Or are you just going to stand in the ring and let him hit you?
That's part of the rules, right? That we have to bring that.
Absolutely.
Okay.
You need to know everything when you walk in those courtrooms. And if you don't, then you need to use an attorney that does for the time being until you do learn that. Because you can cite the case law that will control them.
Copy.
Yeah. And the way to do it a lot of times is do it you move the court to take judicial notice, request for the court to take judicial notice of the statute of the case law, the recording, certified recordings, all that.
Part of procedure. Right?
Yeah.
And if a court makes a mistake or they make a mistake and then you appeal and they
bring it to their attention. You should know that they made a mistake before that. And then you bring it to their attention and ask them questions on their determination.
So you can so basically you file another motion that
vacate it.
Vacate it.
Go back and motion to vacate the ruling because the court erred in its determination. Okay. This is what the court said. Then what you got to have your court report, you put it, this is what the court stated, this is what the law states.
And your
it's
second
never
chance
over
would be
until you don't know. When you don't know what to do, then it's over.
right. And if you make that mistake and you file an appeal in replace of that, and then it goes up to the high court, and the higher level court goes and agrees with the lower court, and they misstate the actual case that you brought in, or they didn't see there was an updated version of that case. At that point, you need to go up a little bit higher to the Supreme.
See, in Dr. Levo was the bad guy versus Westlake. Dr. Levo was the bad guy. He won in the UD, and then he won in the appeal. He won in the Court of Appeals, but he lost in the Supreme Court. See, it's unfortunate we're like that because these guys want to see how much money you got, how much time you're willing to put into it.
Yeah, you're right.
That's it. You have to understand, these are private corporations. They're not like courts like you believe them to be. They're private entities, and they've structured their own statutory scheme in these courtrooms to function by.
So when I got denied or got reverted back to the lower court, I was represented by an attorney, and the attorney was did not file in the Supreme Court, even though I instructed him to, and he just quit. So that's where I have to start all over again, and I have to file another and something else so I can go up the ladder again. That's all I can do, I guess.
And yeah, and you file a claim at the state bar against him. You file a claim against him.
Right.
File a claim against the attorney for,
Malpractice?
Huh?
Malpractice?
Well, malpractice too, yeah, incompetent, representation and, I'm trying to think of the other term. I can't think of it right now.
Yeah, but in your course, your group will help with those kind of or those kind of like I guess complaints and things like that. That kind of stuff as well.
See, our group was here to talk and discuss things. We have people that do certain things, and you can ask for that stuff, but it was mainly because you can do all the paper writing you want to, but unless you go before the courtroom and you don't know how to talk, you're going to get your butt handed to you. Judge starts asking too many questions. What do? Objection. Are you asking a discovery question for the plaintiff? No, I'm just trying to find out about the case. Okay, well, ask him. Isn't that what this guy's paid for? So those are the things that you have to learn. Once you learn how to be able to talk inside the courtroom, you can control the court, and they're going to get upset. They're not going to be all rosy and cheeks and way to go, JD. You're wonderful. Yeah. They're not going to, some of them will like you and some are going to hate you.
Yeah.
But you got to stand your grounds. And there's many ways to be able to stand. That's what we talk about here.
Speaking of standing, have you ever had a judge just get up, all of a sudden just get up and then just walk away?
I've made him walk out. Yeah.
He just gets up and he walks away and he came right back. It's crazy, but never seen such a thing.
Yeah. I made the attorneys walk out of the courtroom because they can't talk anymore.
Well, I would like to add for you, JD, is that what Richard teaches us, not only court procedures, but how to move the court. And you get to be a part of controlling by the knowledge that you're provided in this David versus Goliath.
Absolutely.
Very good.
So how does one get involved? Can you tell us the process?
How does one? Yeah, we have. You go to David -vs-Goliath.org and you make a donation there, and it's $50 a month, or you can pay more, and then you get on each week. Yeah, 2 classes a week.
Plus, you can call us anytime. All of us talk. Tina, Darlene, Lena, we talk all the time. Gavin gets on and yaks with us. We talk all the time. And we feed each other information and help each other with filings and questions sometimes when, Richard can't pick up. So we're all in the same boat. We're all rowing.
It's really nice. It's awesome.
Yeah, I don't know if have you ever heard of a class like this?
Never. This is the first time. I mean, they have something that gives you like documents to learn, but nothing like this interaction. No.
Absolutely not. It doesn't. They don't really have this. They don't teach. They don't want you to know a lot of this stuff. They don't want you to learn how to understand and know what to do inside these courtrooms. They just want you to go and file your paper, go up there, listen to them back and forth, then you're in, ruled against you, and then next, But you have rights.
These UD attorneys and civil attorneys, they just want to take your money, They're not looking to find the flaws in your chain of title and show you how to talk in front of the court and keep your home. I was out of my house, like 3 days going to be out of my house about 2.5 years ago before I met Richard and Jackie. I thought my case was over. I didn't think I had a leg to stand on. Now I've got 2 legs and I'm running. I mean, wow. It's amazing because they don't want you to know, especially the courts and the judges and, these attorneys that are testifying, and they don't even have the right to be up there to have the beneficial interest or hold the asset. It's mind boggling. You get in here for a couple of months and you'll see, it'll make your blood boil. But Richard, and Gavin, Jackie, Darlene, you know, all of you guys, you know, always bring something to the table. You learn something every time. So anyway, I'm super excited to be here. I couldn't get in the room tonight for about 40 minutes, and it was like wrecking my day because I look so forward to it. I used to hate Monday and Wednesday nights. I was like, God, I could be down at the beach or doing something. And now I hate to hang up on Wednesday because I don't get to see everybody till next Monday. So
Yeah. It's
I
one big
yelled.
family.
So can you share how you got your two legs back?
Well, my mother had just taken a settlement on the house that we own together. I wasn't a party to it. She doesn't live here. And Art Villa found my number in the foreclosure court, in the auction, on the auction block. And he called me one night at 10:30 and said I could keep you in your house for another 3 or 4 months. And I didn't have just a long story. So I got started with him, and then I got a little bit of money and I needed to put it in a trust, and he suggested Jackie Fig. And I thought, Jackie Fig, what kind of a fake name is that? You know? But anyway, I ended up meeting her, and I gave her my whole file that my attorney gave me back. And I said, would you give this to Richard? Just tell him to take a look and see if there's anything in there that we missed. She said, he's too busy. And I said, here, take this money, take it over there, see if he'll just look at it. And a couple weeks later, she said, wow, he found a bunch of stuff in there. And I said, okay. So that's how I got started. We found just all kinds of stuff wrong with the chain of title. Substitution of trustee didn't exist. They don't have a right to have their DBA in that state. Just all things that are wrong to perfect your title. So, and plus I was on the grant deed. I should have been a part of that settlement. So it's been kind of sticky, but you know, I know what my rights are, and we're at the appeals court now. And I expect to get a payoff. I think they owe me, my house is worth 2.1 right now. And we paid 912 for it, and they didn't have a right to do this from the beginning. You know, so
Well, did you
I've
have a
got
referee?
about $1 million in equity over here. My house would have been paid off by now, JD.
Yeah, yep. So did you have a referee that came into your? Was there like a ref that came in and listed the house and kind of did that route? The court referee?
No,
Yes.
Nation Star just put it on. They put it on the auction block and, you know, illegally sold it. It sold before the time. There's all kinds of stuff, but I don't remember any referee. The only
So
referee I know is the crooked one in that robe up there in the courtroom, sitting
Yep.
there studying case law for the other side.
So who was they when you say they came and sold it? Was it who was they?
Nation Star.
Okay.
But I'm in bed with Bank of America, Bank of New York Mellon, Nation Star, JP Morgan. They're all of Wells Fargo. They're all in there. I don't know how they're in there, but they are. But it's just little old me against all of them.
That's really David and Goliath, isn't it?
I haven't talked in front of the judge yet. I'm really practicing and trying to learn and trying not to freeze up. I'm a brain tumor survivor, so I really blank out when I get stressed, and it's it's really difficult. But gosh, if you came in here, you're going to be amazed at what you learn. And it's not just learning, it's, you know, it's real soulful. Everybody, you know, kind of talks about how it happened to them. And, you know, we're all in the same boat, and everybody's so helpful. You know, if I can't get a hold of Richard, I can call Gavin. If I can't get a hold of Gavin, I'm calling Darlene or Lena, you know, or Tina or Bonnie, or meeting Bonnie down at the courtroom. She's like, oh, that's you. She recognized me because I always show my face on here. I'm not showing it tonight. So we go to the same courthouse, Santa Ana. So, you know, it's very helpful to have that kind of input and people willing to help you. You know, pick up the phone any hour. Except for Lena, I don't call her before 7. But
What
Richard,
about the
some
judge? Will
people
he,
are
what
texting
about
at
the
3
judge?
in the
Will
morning.
he might, sometimes, the judge is so helpful. Have you ever tried to ask if he'll represent you in the case?
Oh, that's a good idea. Yes, Glenn Salter, would you represent me?
Would you mind representing me in this case too, Judge?
Oh, that's a good one, Gavin. I like that.
I think you already got a job for the other side.
Oh, no, I'm working for the others.
Oh, when
Oh, I
I'm
can't
done
represent both
representing the other
sides, sir.
side.
That'd be a conflict of interest.
Oh yeah, you can't get the paperwork filed. It's missing this and this and this. But I don't give any legal advice. I don't give any legal advice.
Can
Yeah,
I
they're
have some legal
terrible.
advice, please, Judge?
Gavin goes into the courtrooms even when he doesn't have anything to see how they're navigating in there. And you hear them reciting case law all the time, don't you? Yeah, they just stick up for the other side. My last hearing, Catalina Bowman, I think, said about 2 sentences, and we were in there for about a half hour, 40 minutes. And he was
So-
talking the whole time.
Yeah, we don't record the hearings. Is your microphone on? Oh yeah, okay, thanks. I mean, they have video, they have all this stuff, but we don't record anything. These hearings are not recorded.
But in like kind of a summary of overall, when I first got started, I really wanted to, I really did my best to try to figure the paperwork stuff and the administrative stuff out. And I realized that the paperwork only goes so far, even if it's really good. Oftentimes it's not, but even if it is really good, the court, it still comes down at the end of the day, going into that courtroom and the court then challenging you. I've noticed that in my case here, or other people's cases, sometimes the paperwork is really good and they hired somebody to write the paperwork for them. They go into the court and then the judge is going to ask them, so tell me about your case. Well, I just want to stand on my paperwork. And the judge says, no. You gotta wait. You can't, in these state courts, it doesn't work that way. Maybe in federal court, it could. But in state court, it still comes down to, okay, I see you filed some paperwork. Now, what's this case all about? Go ahead. And believe it or not, the other day, as long as there's a court reporter, or if the court reporter's there, the court, they do a pretty good job. Now, without a court reporter, forget about it. You're in for a wild ride. But now that's with a court reporter on the record. I've noticed they do a pretty good job. They're going to listen and they say, all right, what's this case all about? And they're going to want to hear everything on my side, what my point is, and what the other side's point is. And, as long as we stay on point, raise the objections, ask the court to take judicial notice of whatever documents that we brought before it, and listen. Then it comes down to, all right, now listen, like a boxing match. What's going to happen next? If the attorney then begins to make statements of fact, oh, Mr. Mayo, he didn't make his mortgage payments. I'm gonna say, objection, Your Honor, attorney's testifying. Wait for the court to respond. Your counsel, that's a statement of testimony. I'm gonna move to strike that from the record, Your Honor. Now that's on the record. That's going to be in the transcript. Oh yeah, counsel testified right there. He said a statement of fact that wasn't in evidence. I didn't make a mortgage payment. So it really comes down to listening. Because if the counsel wants to bring up any facts, that's a perfect time to object. Because if he wants to argue, fine. But if he's talking about facts, and I'll tell you right now, a lot of times these attorneys, like what you said, the attorneys don't have their paperwork filed right with the court. And a lot of times it's usually just a large law firm representing the case. And if it's a law firm and they got multiple attorneys coming and going, or maybe they just pull somebody out of the hallway, that's when the special, objection to first of all, asking the court, is this the attorney of record or is this the attorney, or is this a special appearance attorney? And then identifying who it is. And I said, well, if he's not the attorney of record, meaning did he file the complaint? Did he sign the complaint? that's not the same attorney, said, well, I'm going to object to this attorney being a part of this complaint today, being a part of the hearing today, because I never got noticed. I've received no notice. And on 285 specifically says that, before the attorney's changed, that attorney's got to give notice to the other side. And says, in order to change the attorney, you got to give notice. So I'm going to object to this attorney being in this hearing today at all, because I never received notice of him being properly before this court. And really right there, 285 could be enough oftentimes if they're not bringing forward their paperwork. Think about it. The attorney just shows up and you've never seen him before. He's not the guy who signed the complaint or who's part of the complaint. That's a really common one. Well, the other one is 702. I don't think 702 I think 702 is constantly underlooked at, undervalued, because once the objection is made, what does evidence code 702 say? That party has to show his personal knowledge. So if you object under 702 of the evidence code, now it turns on the other side. Okay, well, what personal knowledge do you have to bring this matter before the court? You remember the transcript that I shared a couple of weeks ago had evidence code 703. And remember, the judge was the only one testifying in the case. In my case, we went through the record. There was no testimony from the plaintiff. I was trying to testify. He wasn't really letting me, but then who was the one testifying? He says, I've got no doubt that the person who signed the complaint is the most knowledgeable person at the corporation. He's more knowledgeable than anybody higher up the food chain. And this is what the transcript says. So I said, Judge, you testify here in this case. So I'm going to ask the Madam Court Reporter to please swear in his honor. I've got a few questions to ask you about the plaintiff. And evidence code 703 says the moment the judge is called in as a witness to testify, it's cause for a mistrial. So 703 is another one. Evidence code is underutilized. Oh, well, at least it seems like it is. I never really knew about evidence code until I met Richard. But evidence code is huge. So any last comments or questions, Richard? Anybody else?
Not that I know. Anybody got any comments, questions? That's it.
Hate mail,
Yeah, hate mail, love letters.
tomatoes,
Yeah,
rotten eggs.
there you go. Any suggestions?
Yeah, get a new hamster, Richard. They
Yeah.
run faster.
There you go. That's I need to get that hamster. So I hope everybody learned something, because I did. I did. Yeah.
Yeah, I'm trying to figure out how to learn how to tie my shoes. I have these Velcro straps on them. Can you teach me how?
Yeah, we can. We can tell you. First, you got to untie them and tie them together, and then you throw them over a rail, and then you hang it around your neck, tie it real tight, and then jump off.
With cement?
Yeah. Yeah.
Yeah.
That's
the Velcro straps won't do it, huh?
No, Velcro. No, they'll break loose. You want to get something that keeps you hanging around.
Nice.
Anybody? Got any comments there? Hate mail?
I put all my hate mail in the chat room.
All the hate mail in the chat. There you go.
Yeah, that's
rotten
what
eggs,
Yeah.
tomatoes.
You talked about court reporter, and I just wanted to tell you that you think they are neutral, but sometimes, you get a court reporter that when you say I object, they translate that to it's a test. So in the transcript, it says, it's a test, Your Honor. It's a test instead of I object. It's just a random thing. I put it in the chat room so you can take a look, but it just, it's almost like you need two court reporters sometimes, or you have to get your own court reporter. Would you suggest that as opposed to using the court?
Always.
Mhm.
If you can't get your own, because you're going to find out that for some reason or another, the one that you took in there is going to be against you, and they couldn't get they couldn't hear everything.
Mhm.
That's a risk of getting one of the court, using there's a form where you can fill out a form and it says request for court reporter by party with a fee waiver. So again, it does run a risk of doing that because, the court may think, well, this guy, he's a pauper, he can't afford anything. We'll give him the bottom of the barrel service, and we'll just give him some lousy court reporter who doesn't listen and doesn't really write down things correctly. So you may be they may do that. I wouldn't doubt it. When I had my most recent court case we went through, I think I had 4 or 5 hearings with court reporters, maybe 6. Oh my gosh. It was $500 just to show up, just to walk in the door, even if the hearing was canceled, $500. Okay, just to be there, nothing happened, I had to pay $500. Then it was okay by the amount of time in the transcript. So I think I paid usually plus the $500, probably about $850 per hearing. Sometimes one of them was like $1250.
Yep.
Then after they're all gathered together, so I'd say probably about $4,000 of the transcripts. Then I thought that was it, but then we got the appeal putting together. Okay, and on the appeal, she then said, "Oh no, I got to charge you another $550 just to bring all these transcripts into one thing." I'm like, I thought I paid everything. I said, how can I pay? How can there be anything else? Oh yeah, we got to do the appeal. It's a special transcript. They all get combined into one. I said, does it work with me? Oh no, it's mandatory. This is a court required fee. You can't get around this. I said, oh.
You're in the wrong
nice.
business. You're in the wrong business.
So I think it ended up being this is just online. I don't know, 6 transcripts. I made like $4,500 in transcripts.
Wow.
To really appeal the case properly. So yeah, is it fair? Well, I mean, again, you're getting a free court reporter, so they're probably not doing it. Maybe they don't do it right. I don't know. But is it worth all that money that I paid? Well, it's going up an appeal. I got a full record, and we're going to make case precedent out of it. So because there's some really serious issues that are going to have to be, I'm going to set an example of the case. One of the things about the verification of the complaint, we talked about it earlier, 446. Does the complaint need to be properly verified? Does 446, which says that it can be made on information of belief, but it doesn't set forth facts. So if a complaint's signed on information of belief, that complaint does not set forth facts before the court. That's right in 446. So the attorney verifies the complaint, where a third party, who's not the plaintiff, on information of belief, what facts is the court relying on to make its determination?
Hearsay.
Well, these are questions for the appellate court, because ultimately these objections are raised, and like, for example, my case, are all raised on the record inside the transcript and on the motions and inside the court. Now the trial court found that 446 is permissive.
This is a civil case? It was a civil case? Is that what you're saying? It was a civil suit?
No, we don't have any, we don't deal in criminal court.
I understand. Okay. And that's why I brought up the declaratory relief. I thought that might have been an idea. I know that might not.
Well, I mean,
procedure.
filing another cause of action for declaratory relief is a great complaint. I mean, again, it's starting from scratch. You want to start a brand new cause of action. It is a great way to go for filing a complaint. Now, I love declaratory relief because 1060, it allows you priority over all other hearings. But again, that's like saying we're now going to talk about something totally separate from what we're doing now.
You would call it
that's
separate.
a brand new case. So
You would think,
and it's a great though. I think that's the best type of case to file, because you're on one cause of action and all you're asking for is a decision as a matter of law. But you got to be ready to move for summary judgment, because declaratory relief is not going to be heard at trial. And either they're going to bring summary judgment or you are. And so by going into a declaratory relief complaint, it's kind of like if you're not planning on moving for summary judgment, you're just setting yourself up to lose.
wouldn't you want a summary judgment at that point? Wouldn't you want them, once the facts are and the guidelines are set?
Moving for summary judgment is exactly what you want to do. Absolutely.
Because if you're not getting any relief, sorry, if you're not getting any relief in the lower court, like for instance, if they're denying all your motion, in my case, they're denying my motion to intervene. So if I'm not getting any relief over there, to have a basis that or something that's going to be known, documented, this is where our standards, our guidelines are going to be. This is what you have, or this is what your rights. Boom. Then at that point you can at least know what you're, what game, what court you're in, or what ball field or whatever that you're in. You know what I mean?
Well, there's a lot
Arena.
of other ways to go about it. I mean, 1085. Have you looked at 1085?
No, I didn't hear that at all. I will take a look. Yeah, I didn't hear about it.
Yeah, 1085. That's where you're going to a higher court over the existing action.
Like a mandamus with a writ, maybe?
Exactly, a special proceeding. Now that's going to be reviewing what's happening. Declaratory relief is a brand new complaint, has nothing to do with your existing.
Right, and then, but wouldn't you be able to get a stay on your existing?
No.
With that? No, okay. Only the bankruptcy.
Yeah, declaratory relief is about a new case for new facts, new law, has nothing to do with your other case. So it could be great, but they're not so that would be about filing a brand new case about something new. I mean, if you bring up another case, the court's going to think, well, this is, it's just not relevant.
Why would you say it's about another facts if it's the same situation, like
because a complaint is about new facts and new law. You're not going to try to appeal. A complaint isn't an appeal.
No, that's true. But if you were the defendant, you weren't bringing the claim in the first place, right? You were just defending what they were bringing, against you. And now by filing the relief, you're actually, portraying what, instead of countering, you're actually bringing something, on your end.
Bring forward a new cause of action. That's good.
Right. Right.
It has nothing to do with another case, though.
Okay.
So like a 1085 is good because it looks at like, hey, what happened in this case? 1085 is good because that sounds more like a 1085 writ.
Mm-hmm.
Look, this is what's happening in this other court down here, Judge. I need immediate help because they're not following the law over there. That's a great, that's like interlocutory.
Right. And then what are your thoughts about going, sorry, what are your thoughts about going to a federal court and moving? I know somebody was mentioning that they're moving their case to a federal court. Do you have any thoughts about that?
There's general things. I mean, this is just like ideas. There's so many general things that can be done, but it really depends. I mean,
well, because what I was understood is that
it's really hard. It's very challenging. Very challenging. Well, very challenging to do. First of all, in order to consider something like that, there would have to be a complete record. Okay, and there's something called the doctrine of oh man, St. Michael always brings it up. England Jennings reservation has to be made on the record before going to federal court. Otherwise, there's no hope. Now, again, you're just wasting time. Okay, yeah, just wasting time. I guess that's fine. But to actually have a genuine federal cause of action inside of a state court, the England Jennings reservation must be made on the record, and that means that the very first appearance in the case, you're saying under England Jennings, I'm making my reservation that I'm going to try federal issue questions in a federal form at the end of all my state remedies. State remedies would be, I'm dealing with the state superior court. I then filed a writ. That was denied. I filed an appeal to the Court of Appeal. I lost there. I filed to the state Supreme Court. I lost there. Now my England Jennings reservations is ripe. Now I can now try federal issue questions after all that. That's years down the road. Yes.
Yeah. Which is a due process violation or no?
Due process, federal issue questions.
So you'd have to go, all the steps on the lower to the appellate to the Supreme, then you can hit the federal for the due process?
So England Jennings, the case England Jennings is the, what's called the standard for that. Now, that's setting the foundation, because the federal court, they have another doctrine under there called,
Yeah, I know.
other doctrine. It says that
And-
the state has to be exhausted first before
Right.
they just go and look at all these questions. If it's about a case,
Right.
now if it's a brand new cause of action, that's nothing to do with it. But if you're actually looking at a specific case that's going on or has been going on, that has to be dealt with in the state court first, before it goes to the federal court. It's tough to make that, to reach that federal question level.
So you can only preserve your rights at a certain point in your trial case? You can only, it's
Only
one,
if you preserve them under the England Jennings doctrine.
do
England
you have to do
Jennings,
it immediately, or can you do it anytime?
yeah,
any
as soon
point?
as possible, that has to be on the record. England Jennings says that, the party is preserving all of
Right.
his constitutional and civil, due process questions to be heard in a federal forum at the end of the state proceeding.
Mhm.
So once the state proceedings are all done and, there's no more hope left, then they can be brought in the federal forum.
Were you saying something about the res judicata? Is that what you're talking about? Like it was already tried? Is that what you meant?
Res
That you have to see-
judicata is about, well, that was what an attorney was, raising that earlier, I think, on a case. He was saying that all these issues have already been raised in a case as res judicata.
Is that what you mean by that we have to go through the steps? You have to go to the lower court first and then that route?
No, res judicata means that the court has already made a determination.
Right,
on-
which was to deny you of your due process, I guess you would say.
How is that a determination?
Oh, I guess, yeah. I mean,
Isn't that a conclusion?
I guess it's a conclusion, yeah. Okay, yeah, that's fair. Okay. So it's
Yeah, so that's a conclusion that you have, but not a conclusion of law.
That's fair.
So you may argue that, but that again could be preserved as a cause of action
Mhm.
in a federal form.
Can
The
I
courts
ask you about?
really are very harmonious when you really break them down, and they work very, very systematically. It's like a very equal. We may not think so, but they actually look at it as equal to the other side too. And we may not think that, but if they just took up everything on the federal court on everything, and they took them all away from the state court, that doesn't really seem very balanced. It actually does make sense if you think about it. Balancing. Well, let the state court work it out. If the guy reserves his rights under England Jennings, we'll look at it and raise the federal questions at that time.
So
Yeah.
have you ever heard, I'm sorry to interrupt, have you ever heard about the federal court maybe having a different, a different level in terms of like an article? Have you heard this Article 3 court?
Article
as
3?
Yeah. Have you heard that the federal courts are Article 3 courts? And the state court is Article 1? Or is that?
Well, Article 3 standing is federal court. That's going to be like a constitutional standing question. So that's going to be under, what's the pleading standards in federal court? 2 cases that are
Are we talking about
Article 3 standing. There is an Article 3 standing question. So that more comes from the plaintiff. The plaintiff needs to have Article 3 standing, meaning that he's been damaged.
Right.
And then
Even if
he's
he
been
pleads the fifth.
damaged, he has to show an actual damage, like, oh, look, judge, I paid this amount of money out and I was damaged, when they put this on my credit report.
Right.
I can't buy a car now because he's got this bankruptcy on my credit report from another person that's like my bankruptcy. And I'm just showing, look, I applied for this car loan for $15,000. I got denied. I can't buy a car now because they're reporting this on my credit report. Now that's standing. I got Article 3 standing.
And would the standing happen even if you plead the fifth, or you decide not to, to be silent? I guess you would say. Would that also be considered enough to go to the federal court at that point if you just plead the fifth in the lower court? Or is that only for like maybe a criminal
Well, I
court?
think you're talking about being tried as a criminal.
Yeah, with Fifth Amendment, I mean, I would imagine that it would still be relevant even if just to the right to remain silent. I guess wouldn't that still even in a civil court or anything like that, or wouldn't have the same?
There's a case, was it Shabatsky, 1969. I have that case. It does say that the Fifth Amendment does apply to civil cases, but if I remember right, it said that it also creates what is it called? It creates a
mess.
Not a mess, but it's,
you're stumping them. You stump them like, oh, I don't,
you're doing what's called a silent. It's like a silent admission, or it's tacit. It's like you're doing a tacit agreement by your non-response. They're saying, well, he's not responding, so it's kind of like, well, he kind of admits it. Yeah. The court doesn't look fondly at that.
There's so much, but you know what I really commend? I really commend that you go, that when somebody said that you go to the courts and listen. I mean, that just shows that you have determination and that that you're really in it. When you hear that somebody's going to court and it's not even their case, I mean, it's amazing. So more power to you.
Going into court, especially in preparing. I mean, when I had Judge McGuire, I went through 4 judges to get to Judge McGuire, and the presiding judge was finally he recused himself, from the case at a summary judgment hearing. When I went into court, summary judgment, and I lost at summary judgment, but he took it under submission. And I found something in the record that I objected to. And I said, wait a second. I found something in the record from a clerk that she basically what happened was that she said that I found some what I called exculpatory evidence in the case that was kept from me. And it was enough for me to bring forward and challenge the presiding judge's authority under 170.3 to say, Judge, I think that this wasn't, you should have provided me this evidence. This was exculpatory. Had I known this about this case before, I would have acted differently. And it was an internal memorandum that I found. Okay. I presided that in a challenge under 170.3. He then recused himself. He says, I'm out of here. Have a nice day. I vacate everything that's happened in this case. I was like, oh my gosh, this was like right after Christmas. I remember. And I thought, this is like a miracle. I'm getting another chance. And so the judge recused himself, the head judge in the big court with all the big jury boxes and coming in there, and I lost big time. I knew I lost, but he took it under submission. So I filed that in, vacates the summary judgment, and then sends it over to McGuire. And when it went to McGuire, I just would start going into McGuire's courtroom every day. And it was like 30 miles to this court. It took me forever. It was an hour there, an hour back, just to go in the court. Okay, it was ridiculous. And I'd go in there, but I'd sit in the back and I'd see McGuire looking at me. Who's that guy in the back? He wouldn't say anything, and they wouldn't object. This is, I would just go in there and listen to see how he treated the defendants. And if there was pro se defendants, what they would do, and I would take notes and listen, because then it got me a lot more comfortable when I went in there in front of him to see what he would do. Now I still lost. I still lost. Okay. I won. No, I was still too new to win. Okay, but I thought I won. But I remember when I finally was ready to go up against him, the attorney came in, and here I am. I had so much prepared that I put the judge to sleep. It was too much. We had a transcript. It was like 2.5 hours on a summary judgment. Most of it was me just babbling back and forth about nonsense because I thought it was important. And
you believed in it.
The judge went to sleep, and my buddy was there with me, Dale. He was there. He's like, and this is like on the transcript. He's like, Kevin, McGuire is asleep. I'm like, what should I do? He's up there. I'm like, oh my gosh, should I I don't want to be rude. You know, just keep going. Just keep going. Like, okay, I'll just keep going. I just keep talking about the record, you know. The court reporter's still transcribing. The counsel's looking at me. I'm like, what are you saying?
Well, she was loving
So-
it. You were building up a big transcript. a big,
Oh yeah, huge bill for her. She loved it. She got a
She loved
giant payday. So I built the record. All of this nonsense that had nothing to do with the case. You know,
This is
because at
what-
the end of the day, if I didn't understand at the time what a tribal issue of fact was. I didn't know what that meant. I didn't know that I had already waived all my issues when I did a poor answer. I answered
Oh.
the complaint with just by doing a general denial. I can't bring this stuff up, but the judge knew that. That's why he was sleeping, because he knew this case was over before it started.
Uh-huh.
But he's giving me my chance to do my due process, you know.
Do you mind explaining that? Can you mind explaining that you gave it up because you did a general denial? Is that what you said?
Yeah, because when the attorney filed the complaint, I got a chance to answer, and I got a chance to bring forward and show my cards. And instead of showing my cards, what I did is I put, I'll just generally deny everything that everything in the complaint is false. Okay. Then I put in a couple things like, oh, you know, estoppel, res judicata, some bogus affirmative defenses. None of that applied. So I waived my right at that point to bring forward any defense, because I didn't bring it forward.
You couldn't do an amendment,
I could have,
I see.
I could have amended it, yeah.
and you couldn't do that
Had I
in
known to, I
court?
could have.
You could have done that. Couldn't you do that in front of in court when you were actually at the hearing?
No,
Or
it's
no?
too late by then.
Too late,
You know, that's not due process to the other side. I would have had to amended it before the hearing, and I could have said, oh, I want to amend my answer. I forgot to put any defenses. I forgot to put any of this stuff that I want to talk about today in my answer. You know?
And what
know-
happens if you did? What happens if you didn't actually reply on paper and you just went into court as a you know, just appearing and defending yourself? Would they say, "Oh, I'm sorry, you can't defend yourself because you haven't filed paperwork with us earlier"? Or
I don't know. It depends. I've never, I mean,
Yeah.
there has to be some sort of a paper that you're going to be there. Something. You know,
Mhm.
I would imagine, wouldn't there? I mean, I've never heard of.
Well,
filing
so I mean,
nothing.
you can
I
think about
remember
it.
Carl Miller used to say he filed no paperwork. He would just go in.
Was that guy was a real? He was a real person, wasn't he?
Yeah, Carl
Yeah.
Miller, the Constitution Man. You can watch his videos. It's probably
I
some of
do,
the
I do.
best
It's amazing.
educational videos out there.
It's amazing.
You know,
But
some
you
of
know,
the
sometimes
best.
sometimes I think it's like almost unbelievable, like what he talks about, like, you know, how he goes in there and he just shuts them down. You know, before we had the internet, of course, you had the fax machine, right? So you would fax in your answers or your pleading. But before the fax machine, I guess you would mail it in, right? There must have been a time where they, you know, they kind of shortened things or they changed that you know, response time or the actually filing time, because you know they're very into guidelines when it comes to you filing and you getting things on time, but they have no guidelines for when they have to actually step up and give you an answer, you know, or give you a date.
I don't know. It seems pretty specific. 10:05. It says that when I file a motion, you know, I got to do it 16 court days before, give them notice. They have to file an opposition 9 court days before. I have to file my reply 5 days before, court days before the hearing.
And then when you
Now,
file an appeal, when you file your appeal, what would they say there?
They would laugh. Why would I do an appeal after?
I'm saying you filed an appeal, right? So when you filed your appeal, did they give you a date when they're going to hear it?
Oh, my appeal?
Yeah.
Oh, yeah. No, my appeal, you know, it went through right now. Gosh, I filed the appeal last February, so a year ago. No, I'm sorry, March. So what happened then is like, it's going through the court rule process. You know, of course I screwed it up. I did it all wrong. You know, I did the typical stupid errors, you know, laughing at now all the dumb things that I do over time and learning, you know. So I filed my appeal. I did what's called a statement. I wanted to do a proposed statement. I didn't even know how that worked, but I did it anyways. And the judge said, that's all wrong. And he didn't tell me why. I was like, no, it's right. I did it back. Oh, that's wrong again. Did it again, wrong again. Third time, I was like, okay, I'm going to try to figure this out. Let me try it a different way. So I had to go through this back and forth for me not understanding the rules properly, to then finally getting it to where, oh, okay, I want to use the entire record. Now I want to
Mhm.
use the court transcript. Let me do it this way. So now we're there. I finally got past all the preliminary rules on actually bringing a proper appeal.
Yep.
Took a year for me of my own dumb stupidity.
Not
you know?
dumb, it's just learning, you're learning, yeah.
Yeah, my own inexperience, okay?
And
It's not stupidity, it's just inexperience, not
Yeah.
knowing the rules and
no
reading
one
the
taught
rules,
us,
but
no one taught you,
not,
no one taught us.
I didn't know how to use them. I thought I did, but oh gosh, that makes no sense. Now in hindsight, like where I tried to do that, I'm like, that was stupid. Why did I do that?
Yeah.
But it was my own choice. I thought it was right at the time, but the judge, he came back and says, oh, this is all wrong. And he actually helped me out on the papers. He says, you gotta, pursuant to this rule, you need to bring this forward, this forward. Then finally he signed off on it, on the appeal. And
Mhm.
now
See-
it's docketed up and it's going up the ladder.
So you designated your
So-
record, did they give you a date when they're gonna hear everything now?
Well, once I have the brief filed, so
Yeah.
we're still not there yet. But yeah, once the brief, there's a schedule. Everything happens by the rules of court, So
Mhm.
once the Court of Appeal, or in this case, the appellate division, will then come back and they're going to say, great, we got everything. Now here's your briefing schedule. I'm going to get a briefing schedule. So then I'm going to file my brief. The other side's going to file their brief. I'll get to file an opposition. They'll get to file an opposition. I'll get to file a reply. They'll get to file a reply. Then we'll have a fully briefed docket. And then,
Which is a year later. It'll
which
be
is
another year.
when it is. It could be 10
Yeah.
years. I don't know. We don't know.
Right.
When it is, it is. It's going to happen when it happens. But whenever that's fully briefed, then we'll be able to set a hearing.
Mhm. And you decided to do appeal as opposed to vacating or a 473?
I did a 470. I did a motion under 663, which is a motion to vacate.
663 or 463?
There's
Because
two
63
different motions. There's a
Okay.
motion to vacate under see, it's pretty technical, but you really dive into it. There's a motion to vacate under 663.
I see. Okay.
People don't know about this one.
No, I don't. I never heard of that one. That's amazing. Okay, so in that motion to vacate,
No,
you used
hold on,
673 maybe? Let me find that.
no, it's 663. Yep,
Okay.
that's it. That was right,
And-
663.
And you're vacating.
It's called setting aside and vacating a judgment
Oh, okay. Okay.
and entering or a different judgment entered. So I brought a motion under this, along with a motion for new trial. And so once I did that type of motion for the motion to vacate and or set aside a new trial under 663, we heard that motion, argued it out in the courtroom, had a long blowout hearing where the attorney pretty much said almost nothing at the hearing and the judge did all the testifying on the record. I got
Oh,
the
man.
transcript for it. It was really cool. And this is where I called the judge as a witness. And I said, Judge, I want to call you as a witness. And Madam Court Reporter, will you please swear in his honor? And he said, I'm not swearing.
Wow. That's amazing. That's
I don't
amazing.
want to swear in. I'm not here to testify. I said, well, wait a second, Your Honor. This is on a transcript. We were reading this a couple weeks ago.
That's amazing.
We were saying, he says, Mr. Mayo, I'm not here to testify. You're misunderstanding how this rules work. I said, well, Your Honor, the record reflects you testified for the other side. Let me read the record again. I don't need to hear it again. I said, well, here's your testimony. You're saying, I've got no doubt that that party who signed the complaint has the most knowledgeable person at the corporation, more knowledgeable than anybody up the food chain. In fact, he was the most knowledgeable person at the corporation. I said, Judge, I have questions about that factual conclusion that you determined, because I have never met this guy. He's never come to court. He never testified. So this is the only testimony I've got in the record. I have some questions to ask you about how you know this stuff. And he didn't like that, but again, it's just on the record. It's the appeal, so.
So he ruled. So I guess at the end of the day, you had to.
There was a spot, in the deposition when they had changed.
Yeah, he ruled that he didn't want to testify. And that again is a call for mistrial. That's what the record, that's what the evidence code 703 says when the judge testifies, like there's called or refuses to testify. but it was a strategic matter at that point, and I just hung up on it. I got the transcript. I kept asking him about this. The attorney didn't say a peep because I objected him testifying. I objected him saying anything. I was ruthless on the attorney at this
Sounds
point.
like it. Was it a bench
At this
trial?
point, literally ruthless. I said, oh, no. I said, I was like, at this hearing, I'll tell you right now, I had had enough at this point. You know, of course, in the first hearing at this front of this court, I want to be Mr. Nice Guy, clean all this. But after this judge had trampled me, and I was still proper, respectful, adequate, you know, on this transcript, not one out of line, respectful, never raised my voice, but I cut the attorney off.
Yeah,
I would
they're
not
stealing
let
your
the
energy.
attorney talk.
Yeah, you had enough. They're stealing your energy. They're making you do all this stuff, and it's crazy.
Yeah, I said, I'm here. No, Mr. Attorney says testifying. He's raising objection, testifying, objection, stop, move to strike. You know, I just shut him up. He was quiet as a mouse after that. But then again, it was just the judge. Then the judge did most of the arguing for him. But I mean, honestly, I have no problem with that judge. He's a fair. He's doing his part. You know, he's a good. Honestly, I would love to meet him for coffee and learn from him. I think he's a smart judge. He's a former prosecutor up in federal court.
So why do you
Lot of
rule against
respect
you?
for him.
Why do you rule against you? What was the reason? What was his,
Ultimately, it's not a simple, easy question to answer. It's not like, oh, it's right here, boom. It's not that easy, you know, because there's authority in the case that the attorney brought on the other side from the Supreme Court back in the 1800s that says they could do what they did. But my question is that case doesn't apply, you know, because it's old and it's not relevant to the issue of the verification of complaint.
Could you tell us
Verification
what he said? What was the case?
Well, that's going to be a question for the appellate court. Ultimately, that was what the court stood on, an old case. And I said, well, that case doesn't apply for, it still doesn't change the fact that 446 says that it doesn't establish facts. So if they bring forward this complaint without anybody to come forward and sign to it, swear to it, no witnesses, they get summary judgment, and I'm objecting. I'm saying, what facts? Back to the Perry Mason court. Perry Mason comes in, swears a witness, hey, sir, did you see this thing happen? Yes, I did. In this case here, nobody ever showed up.
So no damage party.
Nobody ever. Just no party ever. No damage party. No, nobody.
So who's
Never.
taking you to? So just this lawyer from
Just an
wherever
attorney,
is
yeah.
taking, and who's representing a corporation?
We
or
don't know
some
who
sort of-
just a piece of paper.
Right. Oh, just a
He's
piece of paper. Yeah.
representing a
Yeah.
piece of paper.
Yeah. So technically, you kind of won. You should have won. I mean, that makes
Well, 446, that's my point. 446 says when the guy who does that, it's just a piece of paper, 446 says,
Yep.
On information and belief, you know, he signs that piece of paper. If that's all he's got, it just doesn't establish facts before the court. So my question is what facts did the court rely on to make a
Hearsay.
determination?
Hearsay. That's what they relied
Hearsay
on.
facts. Okay, hearsay. Well, that's gonna have to get overturned then, because that's
Of
not
course.
facts.
Of course. It's just how much energy you have to go and how far you're going to go, because they're trying to knock you down every single way, which is not, that's what they try.
It's, it's okay. I mean,
No, you have
it's
to-
just
you
gonna
have
have
to
to be laid down for what's called court precedent, because this case here is gonna go to the Court of Appeal or to the Superior Court Appellate Division. If it loses there, it'll go to the Court of Appeal. If it loses there, it'll go to the Supreme Court. If it loses there at the Supreme Court, well, guess what? I put down my
Federal.
England Jennings reservation on my first hearing.
Yep. Do it,
So
man. Do it.
I don't need to bring up the constitutional rights questions now, because I don't expect it to go that far, but shoot, I guess if it did, then I've got my constitutional rights questions and I'll sue the court and I'll sue everybody,
You have to.
for all these civil rights violations, but that's
Exactly.
way down the road. But they already
your day-
know
that's your day-
that's on the record, so that they see that in the very beginning, I put in there England Jennings reservation, right in the very first, boom, document I filed.
Love it.
That's
Love it.
gotta
And-
be in there in the first record. And that way,
Love it.
hey, the court wants to go against all that. That could be coming at one point. I don't think it would ever go that far, but I guess it's there.
they're fighting. I mean, that's amazing. You as a fighter, this is the David and Goliath, like you say. It's who's going to give up, and you're not giving up, and that's the most important. You're just going to go all the way. I didn't want to give up on my situation, but I wasn't representing myself. I had an attorney who kind of threw me under the bus in this sense. But I have to start all over. But this time I'm going to do it myself. I'm not giving up, you know. And so, you know, it's like it's you know, more power to you, man. And, you know, just keep the fight, you know, because, you know, by you making by you doing this, it's going to be case presidents, and then a president, and then other people can, you know, can learn from your you know, your journey, you know.
Well,
Amazing.
hopefully we can get, you know, these complaints verified.
Do
See,
they-
that's really what it is gonna come down to, is 446 permissive? Like, can we just rely on an attorney? If I'm an attorney, okay, and I say, oh, hey, JD, you know, I'm gonna sue you, and my client who's not here, he's just living under a rock somewhere. What's he called? Oh, he's called ABC Company. Oh, okay,
Yeah.
cool. I'm representing ABC Company. And then ABC Company's secretary signs the complaint called, and her name is
XYZ.
Linda Green. Linda Green, she signs, there's a robo signer. She signs it. Okay, great. All right, Mr. Here, I got my complaint here against JD. He owes me this, his house. I want to get his house from him, and I've got it. And I filed my complaint with this court, and here it is. And I signed it. And my client, he's not here right now. He's out of town, actually. He can't come forward. He's busy. But I got it. I'm here. So I want summary judgment against JD. You know, and I say, well, wait a second. Who's suing me?
No, Photoshop did it, because that's what they do. They just Photoshop.
And I say, well, sorry, buddy, you know, you didn't raise any triable issues of fact on your answer. So summary judgment in favor of the plaintiff. Well, wait a second. What plaintiff? And that's what 446 is all about. So, well, if they do that, okay, I guess they can do it, it says. But 446 says it doesn't establish any facts for the court. So how can we have a case without facts?
With the railroad. And what they're doing is they don't have people, they're hoping they don't have people like you that they have to go up against. They feel they want to find those people that are just in agreement with the process, and saying, oh, you're a judge, oh, you're wearing the robe, okay, you are supposed to, you know, I just will listen to you and I will just deal with it. But they don't have people. And when they have people like you that are actually knowledgeable, that's when they're having their issues, and that's why they're giving you a run for your money, and you know, it's hard.
It's you know, Dr. Liebel versus Westlake. What happened there? He was sued. Dr. Liebel wanted to kick out his tenant. He bought a house bought a business at foreclosure, and it was what was it, a dental office or something like that. The existing tenant wanted to stay there. He's like, no, I want to stay here. I'm paying my rent. I'm a good tenant. Just because you bought this house at foreclosure, you want to kick everybody out? Yeah, you're out of here. Serves him a notice to quit. He serves it before recording the trustee's deed upon sale. But you know what? The unlawful detainer court said, too bad, so sad. You lose, buddy. You're out of here. Oh, what, judge? A year goes by, he files an appeal to the Superior Court Appellate Division 2016, he loses there. They said, too bad, so sad. You know, tough luck. You know, we got to get you out of there. You're out. He says, wait a second, I'm going to file the Court of Appeal. The Court of Appeal. I said, no, sorry. You know, it's close enough. You know, just because you got the trustee's deed upon sale recorded after you served the notice to quit, don't worry about it. Doesn't matter. We're going to move forward anyways. 2018 comes along, goes to the Supreme Court, California. And they say, wait a second. You recorded the trustee's deed upon sale after you served the notice to quit? So that didn't meet the commission's precedent along the case. So yeah, the Court of Appeals said it was right. Yeah, the appellate division said it was right. Yeah, the trial court said it was right. But I'm sorry, that's not the way the law works. This has to go back. You guys were all wrong. Now all the case of all courts of California are all changed and controlled by this case called Dr. Liebel versus Westlake, and all unlawful detainer courts are controlled by this one case now. And everybody has to, you know, basically reference, oh my gosh, the Supreme Court made a ruling on an unlawful detainer case. The law is completely in stone now, you know, because of these guys, this company that appealed all the way up there and won, changed the whole system. I mean, and so yeah, but if the court doesn't think you're going to do that, you're going to lose.
Yep. And remember, they tell you there's only 1% that gets to be heard by the Supreme Court. So you know, what are you even trying for? You know, that's what they're telling you, you know, it won't be heard. It's only 1%. But I mean, like, how many people are actually, you know, have the path that they're taking, the path like you said, which is the trial court, the appellate court, the writs, and then boom. So I mean, you don't know this, all the people that are actually petitioning that court, right? We don't know who's petitioning to Supreme or not. So what's 1% of, you know, 1% of 100,000, you know, or 1% of 2, you know, who knows? You know what I'm saying? Or 10, whatever it is. So we don't know the
California
numbers.
courts are pretty strict, you know, I mean, for the most part, I've seen, as long as the record's there in the case authorities, if they have the court needs a place to hang its hat. Where can he hang his hat? Meaning that that's the problem, the case that mine's at, you know, he's hanging his hat on a case that I think is not proper. So that the court's gonna have to review this old 1869 case that they're supposedly relying on, saying that, oh, a random guy can just sign a complaint, okay? Any Joe Blow off the street could sign a complaint, that's fine, and you can move forward. I guess that's what the law used to say back then. I don't know, but maybe, but I don't think that applies to the cases. I don't think that the court needs to hang his hat on something, because there's been lots of cases that have come out since then to say that's not true. And so there's a conflict in law, and the court needs a place to hang its hat. So it has to be some sort of other decision that says, wait a second here. What's the stare decisis court say? And what's the case in what is it? Star Motors. Star Motors is the one. It's already been to the Supreme Court, and it specifically said that a complaint or a verification that's signed on information and belief, it does not establish facts. There's no facts, hearsay. It's already been established. It's stare decisis. It's a matter of law. There's nothing to talk about here. So what they're saying, you know, it's a kind of a conflict, and so that has to be decided. So somebody's got to do it. We got to fix this verification problem. That's for sure.
Yeah, I mean, at the end of the day, you know, is statutes law? Does Congress make the law and do the or do they make the statutes, and do we vote in these? You know, do we vote in or vote to agree on them, or does that become law? Or does that become statute? And does the statute, you know, equal the case law? So it's like, it's all so mumbled and jumbled, and you know,
Well,
you know,
the law is actually, that's a really tricky question, because
Yeah.
you know, well, you know, if you really look at it, okay, the real secret is to where is the law, you know, and I'll go back and defer to Richard Cornforth on this, because that's who really taught me this tough question of how where's the law. Okay, because is the law in the statute? Is the law in the Constitution? Where's the
Right.
law? And the way the system's actually set up, okay, is we got 3 branches of government.
Right, 3 branches.
Okay, right, the legislative branch, and that's where the statutes are passed.
That's the Congress and the
Then
House.
Go
right?
to the executive branch to enforce those statutes, to then enforce those statutes, but then it's our job at the bottom, and the home plate, you're looking at a diamond, to then move the judicial branch to enforce to use the statutes, okay, to then cause the executive branch to force somebody to act.
So let me understand this. Oh, sorry.
But where is the law within all that? And so, deferring back to Richard Cornforth again, the law is in what happened with that process, what the court decided. And the courts, what they decided is not just any random court decision, but it's the controlling decision of that actual provision. So let's say 1161 AB3 of the Civil Code of Procedure. What's the controlling decision? Dr. Leal versus Westlake. So what is the holding of that case? That's what's called the annotated code. So when we find out what statute we're under, what's the statutory, the legislative authority, what's the provision that we're trying to be under, narrow it in. Okay, this is our point. We're under this. 1161 AB3, not all these 1,500, 1,000, no, just that one. Now, well,
If
what's
you-
the controlling case?
Yep.
And what's the holding say? Can we use that holding? Because if we
Can we
have that
first, can we
holding,
find it? Can we find it first? Because they hide those annotated.
and
annotated stuff.
but I just gave you the secret formula. The
Yes.
secret formula is identifying what the statute is that this complaint is all about. What's it all about? He wants to bring a complaint under this statute, cause of action. And what's it about? And then under that, okay, is going to be the judicial decisions. Not as a million of them, but inside the annotated code. And back in the day, even as much as I still have the entire West annotated. They
Oh my
don't even
gosh.
make West annotated anymore. Okay,
Thousands of
but I
dollars.
have the entire book. I have the entire thing. It's about 1,000 books. Okay, it filled my entire wall.
It's
And I've got it
crazy.
in my office library right now. So
That's awesome.
you have all these blue books. They stopped publishing them like a couple years ago. But inside of that, you open the book on that statute, and all of a sudden you're going to see the case that's controlling.
The annotated.
They
That's
still
the key.
publish Deerings.
Yeah.
That's the
That-
that's the holding that controls the court.
Yes. Yes.
And then
but you can't find it. You
In
have
addition
to.
to
Sorry.
West annotated, since that's not published anymore, they have Deerings. Okay, Deerings also has the holding. The other place that has the holding, of course, this is in the law library now. In the law library, they're going to have something called like Rudder Guide. This is really, the Rudder Guide is so key because it shortcuts everything. Now it's going to shortcut exactly where the holding is onto that statute, and it updates everything for the judge right there, the current Rudder Guide. The Rudder Guide seems to be really applicable right now to where the holdings are going to be. All the
Amazing.
secret holdings for the court to use, because then the court, he's opening up a guide, a shortcut. There's two guides, either the bench guide or the Rudder Guide, usually are the most, or Deerings. He could be using Deerings. Seems like the Rudder Guide is the main one they use right now. And right there it has the holding case. That holding case is what's going to control the court. So if you bring up some other case that has nothing to do with that holding, have a nice
you're
day.
done. Yep.
But if you find that holding,
Yeah.
boom, you're now
Yeah.
controlling the court, because he's going to open his book and say, oh shoot,
He's
this
got it.
is the case that controls me.
That's
He's
the
got
key.
me.
Mhm.
He's got it.
He's got the key.
Yep,
So
that's
so
the
you were
key.
that's the key. You were saying something about when you're in a home, you're a home plate, so you're gonna be controlling the judicial. But aren't we
moving
in
the
a-
judicial system with the legislative statute.
with
okay.
legislative court though? Aren't we in a legislative court?
Well, that's something, yeah, it is a legislative court, yeah.
Right.
Because
so,
I'm moving the court with a legislative function.
Uh-huh. So we're in a
Exactly.
legislative court. We're in a legislative court, and we're dealing with statutes in the legislative court. But we want to invoke the judicial law. Is that or
The judicial power by moving the court through a complaint or a motion, moving the court with a motion, let's say. Then by moving the court with a motion through the judicial process, using a legislative statute, I then get to enforce an executive power.
Do you see how there's no remedy in these courts until you get to the judicial courts? I mean, for me personally,
Well,
I don't want to speak
that
for
would be a conclusion without, I would have to ask, what facts are you basing that on? Is no remedy for you?
Right, excuse me. I meant that's what I see for my situations, plural. That for my situations, plural. I've noticed that if you're playing in their ball field and they're all on the same team, whether they wear a different costume or whether it's a different outfit, they're still on the same team in the same home team in the same ballpark, right?
Yeah,
So
they're just, you're walking into a poker game and I say, hey, JD, let's play.
Yeah.
And you say, great, what game are we playing? Well, poker. Okay, great. And you forget to ask me, are there any wild cards? Like, oh yeah, deuces are all wild, buddy. But you didn't ask.
Right. And by the way, my friend over here,
full house. I'm like, I got a flop hand with all deuces and I win. I'm like, oh yeah, I forgot to tell you, deuces are wild. Have a nice day. Give me your money. So you forgot what in your case here is they're playing by certain rules.
Well, they're playing with a hot
until
deck.
you know what rules they're playing by, you have no chance.
Right, but they're playing with a
But they
hot deck.
are playing by
right?
rules.
Well, no, yes, but it's their rules. They're playing with their own deck.
They're
Their
playing
hot
with
deck.
their own rules, but there
Yep.
are rules to play by.
Okay. Well, yeah. You didn't. Have you not experienced new rules popping in and out? The ones that maybe you haven't.
No.
You know. You didn't.
No, they don't pop in and out.
No?
No.
So.
I mean,
so,
there's odd times, and that's called for a writ. So
See,
there are
but-
odd times that there's an absolute no clue why something's happening the way it does without any authority.
JD, what he's raising, Gavin, is JD is saying that they're, throwing in some of their own rules and regulations. The reason why they do that is because you don't understand the procedures that they're supposed to accommodate by. Once you understand that, they
Right.
try to still do it, but they're not allowed to. You only
Right.
allow them because you don't ask them questions. So if you ask a question, when there's a question before the court on a California Evidence Code 402 or 403, these are the 403 is the proponent of the pro-offered evidence has the burden of providing evidence sufficient to meet their preliminary fact. Okay. And you ask the court, okay, is it not the burden of the plaintiff to provide evidence sufficient to meet their preliminary fact? And then that evidence is inadmissible. Now it shifts to the court for the court to find evidence. Can the court direct me to the evidence that they're relying upon? The trustee deed upon sale, objection, hearsay, lacks foundation.
when you say the court, you're saying the court, so you're actually almost making it as if you're against the court, right?
But yeah, you are in a sense when you say the judge. You say the court, so it's still the judge. It's
Right.
the
So
same-
you're actually adversaries, the judge in that case, then, right?
See, the judge is not supposed to be the adversary, but
Exactly.
But see, the evidence code tells you right there that the court, if you look up California Evidence Code 403, it says the proponent of the pro-offered evidence has the burden of providing evidence sufficient to meet the preliminary fact, and that evidence is inadmissible. That's what it says. And then it continues on, it says, unless the court finds evidence sufficient to meet that preliminary fact. So now at first the plaintiff to bring it, but then it's the judge's obligation to find the facts. Or to find the evidence sufficient. So what you do is you ask the court a question, and can you direct me to the evidence that the court is relying upon to meet the plaintiff's preliminary fact and or to acquire subject matter jurisdiction? He's going to say the trustee deed upon sale and also possibly the proof of service and the 3-day notice. He'll probably say that. Objection, hearsay, lacks foundation. Now it's up to you, even though they have the ability to be able to just do things without having, they don't, if I always tell people if they're 100%, you got to be 1,000%. So we're going to take it to another level when we go inside there and argue and fight these guys. We're not going to leave anything to chance. So we hold them accountable to that. I can tell you that I've had people that were defendants against the bank beat them in a UD courtroom.
In a lower court?
And a UD courtroom.
Oh, what? In an unlawful
An
detainer?
unlawful detainer courtroom, several of them, in a jury trial and in a trial, bench trial.
Bench trial?
Yes.
Ooh, I like that. Okay, I like that. That's
No,
awesome.
But you know why? Because you got to come in there. See, they created a statutory scheme. It tells you.
Yep.
The Supreme Court tells you. The Appellate Court of Appeals tells you that it's mandatory that they adhere to that. And all you got to do is show that they didn't.
But you're showing the lower court, the UD court, that they're making that they're in error. I mean, why would the judge? Don't you find that they want to stick with it and they say, you know what?
Hey,
I'm
Cynthia, look, wait, Cynthia, when you first got your UD courtroom and I took it over and started helping you, did they continue with the UD courtroom? Cynthia. Maybe she went.
I suspect you're saying that they didn't. They switched out. They left.
No, they dismissed it. But
Amazing.
I got cases where I've won inside there.
But you're not. But you're not there, right? You're helping. You're just helping your guys.
We put the paper together and we have the attorney go in there and run it. But he understands the statutory scheme because you have to understand. We have the case law that tells you to duly perfect title, you have to duly perfect the sale. You've got to do one before the other. You can't just jump to this. And when you walk into the courtroom, you don't stand there like, here's what I have. I've gone into court by myself before for other people when they grant deeded to me. And I said, okay, Your Honor, I walk in there, the judge didn't know me. And he says, Mr. Menes, since you're a pro se litigant, I'm going to give you a lot of latitude against these two bank attorneys. I said, okay, thank you, Your Honor. But after the first 5 minutes, he said, Mr. Minute, stop. He says, I'm taking away that latitude. You're on equal footing with these guys. I never let him talk. Never.
And you said, and you were able to do that because they granted you the property, and then you couldn't.
As long as I have a grand deed, a percentage of my name, I can go in any courtroom and talk about it.
Amazing. And is this part of the program? Is that what you?
No,
is
it's
that-
not part of the
that-
program. It just that's what I used to do before. And then they put me on investigation for 14 weeks because I was beating them up too much.
You're lucky that's all you got.
Well, because they tried to do more than that to me. They put me with the DA, but I told them what I was going to do to them because I understand federal law, and federal statutes and codes and evidence codes. And I told them under Title 18, 241, 242, depreciation under color law. I said, look up Rule 34. It allows me to collect all your electronic equipment. I told that to the guys that came, that when they came here to talk to me, the heads of that county. And so they left me alone. So I went to the DA and asked them. They said, no, they adopted it. And I said, okay, thank you.
Amazing.
It's not amazing. You know what's amazing is that
It's amazing. No, it's amazing that you beat that you're able to shut them up because these guys they're tough. They're tough.
No, they're not.
No. Okay.
No, they're only tough because you don't know how to be able to deal with it. It's a federal offense. It's a 10-year prison term and a $1 million fine for them to be able to intimidate you under color of law, to harass you, to be able to do any of that stuff. And as long as you've got evidence to be able to show that and phone records, phone records, card, all that stuff, you can take it. And they ain't going to want to do it.
And take it to where?
Federal court.
Okay, that's what it is. Yeah, the Article 3 court, right?
You can call them Article 3. You got to get all that junk out of your head because you ain't going to. That's all that stuff's an illusion. You're in Disneyland. Stay out of that.
Okay.
You know, get into the real world because what these guys have created their own scheme. They got you got that says Superior Court, but that's a 7-Eleven store with their own policies, rules, and regulations and statutes.
It's a franchise.
They created that. So when you walk inside there, there's a certain amount of certain things that will work inside there, but you have to understand that that's what they work by. And they got tons and tons of case law that when you go inside there and they don't comply with it. So Gavin.
Amazing.
Gavin, you there?
Yeah, buddy, I'm here.
Okay, let's say I file a claim against you right now. I just took your property, and when I put my I didn't record my trustee deed upon sale, and I filed my unlawful detainer, served you the 3-day notice, and then when I went inside there, you pulled the trustee deed up, and you found out that it wasn't recorded yet. It was recorded after I filed all that stuff. What can you do?
Well, that's Dr. Leo versus Westlake. I would definitely file I would file a demur and a motion to strike.
Absolutely. It'd be gone in a heartbeat.
And then if that didn't work, I'd go for motion for summary judgment because there's no, Dr. Leo versus Westlake specifically says that, if you filed your unlawful detainer before recording the serving the notice, I'm sorry, if you recorded your trustee's deed upon sale prior to serving, after serving the notice to quit.
Yeah.
It's the court lacks jurisdiction.
Absolutely. And that's what it says. And every time they do it, it gets reversed every single time because it's a statute and code that they abide by. All the case law gives us the reason to be able to go there and beat these guys. It's just that you have to be able to stand on the merits of what you're doing. You got to know your stuff.
Yep.
You got to listen to them.
And you teach that in is that something that you guys?
This is everything that we've been talking about. We talk about the statutory scheme since it was enacted back in 1920 when they couldn't take out a homeowner out of the property because they brought him pursuant to 1161, a landlord tenant issue. So what they did is legislation went with the banksters in there and recreated 1161A with a complete statutory scheme. But they didn't bank on us learning how to understand this stuff. Once we understood this stuff, then it's game over.
But Dr. Liebel is 2018, isn't it?
Yes, it is 2018.
So
It's
what happened?
It's a Supreme Court case ruling, California.
And before that, you were just using a different you would just use a different case law, or there was just nothing like that?
Oh no, we have there's all kinds of case law for this,
right.
But you don't know it because you're not in this game. But when you get in this game, you got Kessler versus Bridge, you got U.S. Financial versus McLeodis, you got Preciado, you got.
So when I don't know how you entered this, but for me, and for most people that I spoke to, we come into this once we've already realized that the courts are not equal, I would say, or not neutral. And then you come in like, okay, well, you're kind of on the kind of like kind of knocked down to the bottom. You're trying to get some air. So you're starting really 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 low. You're actually negative. So is that how you find people coming into this
Everybody comes in here, they say they wish we would have known about your group before that.
So how does
Everybody, all
so,
these people here.
it's everybody, right?
Yeah, everybody came in here like that. I've been at it since 2010, 9. And what happened was I was with an ex who was going through a problem. I didn't have any problem, but she did. So I went and did it. And then I learned the federal rules and the state rules. But they beat me the first couple of times and I got mad. I said, I got to find out this game. I said, I need to know what's going on. So I started studying and learning and research. And I went through the whole gamut like everybody else. And listen to common law, maritime law, amateur law. I started looking at all these things. Article 3 courts, Pennsylvania is the only one. I started looking at all that things and it didn't make any difference because the Supreme Court of California said that the non-just foreclosure, well, actually, they say the creature of statute, but it's a contract. The deed of trust is a contract. And so therefore, when two people enter into a contract, you have the right to be able to sell it pursuant to the conditions in the contract of the deed of trust. So, but there's so much more to that. But when you get in here, you're going to start learning. You're going to learn a lot. It's going to open your eyes to a lot of things. Because, there's all the stuff that they're doing against you. They don't really have a right to pursue the Constitution, but they do all this stuff.
Yeah, they put and of course they're trying to pull anything out of their whatever they can find. So how, do you offer some sort of like a different plan or like a different structure in terms of like I know twice a week you have that, but do you have something else that's maybe for somebody that's like immediate kind of like assistance or something?
Yeah, you can talk to us. There's some of us on here that help and do things like that, but it's like cost of anything else. I mean,
of course, it's your time.
You look at the things that you're doing. We look, see, are you, but
yeah,
it's like people, a lot of the people, like most of the people that we deal with right now are people that are already, that have had homes or lost homes or want to, get their home back or do things. You look at the certain statutes that they fail to comply with, and we file them that way, just like Lena and Cynthia and Bonnie. We filed civil lawsuits against them, and Cynthia's they answered, Bonnie's they demurred hers on 6 accounts, on 6 causes of action, and then the court overruled their demurs and they had to answer. And then Lena's, she had 5 causes of action, and they demurred them, and they got their butt handed to them too, and so they have to answer too.
Wow. And by and I mean, is there a certain time? I mean, I don't want to take, I feel like, of course, everything is, all you have is time, right? That's all, you can't get that back. So is there a way that I would be able to, have somebody review the case and kind of do that? Or is that?
You can get in contact with me, because I think you talk to Slim and stuff, depending on what you want to do. And then, Gavin, some of the other people are caught up so much in their stuff, but Gavin, me, and a few other people we're looking at the stuff and then going at it. And we also have another girl that's come on right now, Kim, and I really like her and her background and what she's done and some of the things she's going to be doing and stuff like that with us, because she comes from more of a law background, whereas I'm a street urchin.
Yeah.
I learned the going through the street,
Yep.
And so, but I learned everything. I've learned everything from securitization all the way to bankruptcy, all the way back down to everything like that. So,
well, I have a hearing. I have a motion. There's a motion for a writ of possession on 11th.
Yeah. See, and you have to see. I had a guy had one the other day that was going to go in there. I told him just go in without it. Go in there and just state that they never served you. Taking a photo of your mailbox being open, so that somebody stole your mail. And so I didn't have time to respond. So I need at least 14 days to respond. The court said, "Okay, granted."
Okay, so you got 14 days, and then what happens at that?
Well, now we got 14 days to respond.
Yeah, but I mean, do you have an idea?
She set out till May something, I think, May 1st or May 3rd.
So then you guys have something that you're gonna fire back
file
with?
an opposition to that. I won my first opposition in federal court back in 2011. Going into federal court. And I objected to attorney testimony. I objected to them submitting their documents. I objected to everything. I objected to all that stuff.
I mean,
I wasn't even on the deed of trust. I wasn't even on the contract.
Wow. So I mean, I put stuff together, but of course, my situation being that I actually motioned intervene. I feel like maybe I was already in the case, and my lawyer was just messing around, kind of like, trying to, make, billable hours, I guess you would say, and then just motioning to intervene, even though I was actually in the case already. So I don't know if, if me being not served, it would have to be, this motion would be a way for me to, to ask for a continuance, or to, to hold off. But it might, I mean, I'm definitely, all ears, and
Well,
you
see,
know,
an emotional relief from automatic stay, man, it depends on who the judge is and where you're at. You're in LA?
I'm in LA. Morris Leiter, his name is Leiter, LA, Stanley Mosque.
I'm
Yeah,
talking
so-
about the bankruptcy judge.
So it's not bankruptcy. No, I didn't file bankruptcy. It's a civil action partition case.
Okay, and you're the defendant in the civil unlimited?
No, I'm not named. I'm not the named defendant. However, I received interest in the interim.
Okay, and so you put yourself in, you interpleaded yourself into the case.
I tried to, but I was denied.
Huh.
And then I went to appeals court, and they denied me too. And I brought case law. We brought case law about, and they didn't read
Yeah,
the right.
those guys are something else too, man.
Amazing. They're
yeah.
crazy.
Then
They're
you have to do a request for review. You got to put in a petition review into the Court of Appeals.
I did that. They denied it. And my lawyer was supposed to go to the Supreme, but he stopped. He just like dead in the water. I'd never seen something like that in my life. He just says, "You lost." I'm like, "What do you mean?" I said, "What about the Supreme?" He goes, "Well, it's too late." I said, "Well, we talked about that. I told you." No, I said, so I called up the, I'm trying to get the, I try to find, try to run around, try to get to the Supreme. And then he's like, "Oh, it's only 1%. He's doing the whole bullshit." But what I think is this: I think they kind of called him up and said, "Listen, man, Scott, I think you exhausted everything. Let it go. It's our turn to kind of take over. Or you can get the other win next time," kind of thing. That's what I think, because he just stopped, completely stopped.
Wow.
Yeah, it was unbelievable. Yeah. So everything would be okay, but they actually filed a motion to vacate. They brought me on the record back into the case. That's the only option I think I can see, because before I wasn't in the case, quote unquote, right? So they could just railroad me. But now they brought me into the case by saying that there's a motion to vacate me from my unit, so I can go two ways, right? I can be the owner that did not decide on to sell the property, or the tenant who has a lease, and that is ability to stay in his unit. So it's really, I'm really I'm kind of like trying to figure out which route to take.
Well, yeah, you're in a civil unlimited. That's a little bit different. In a UD courtroom, you can still challenge, even if you're a tenant and underneath the lease, you can challenge, because anytime they bring an action pursuant to 1161A(b)(3), they have to. The burden's upon them to be able to prove that the property was duly sold or duly sold
or agreed on. Yeah, I like that one.
Yeah.
But that's the UD. That's UD court. But what about? I mean, how could they get rid of possession without going through the process? I mean, it could just say, like they want to claim that I'm an owner. If I'm an owner, then I have rights to my property. Then I should be able to object, or at least be able to agree if I want to have this referee, quote unquote, because that's what they.
So are you signed on anything, or do you have anything?
Oh yeah, I'm on the D. I'm on title as a tenant, joint tenant in common. Excuse me, and the title. It's already recorded.
So then they never they have to contact you before they can foreclose pursuant to 2923.55 to work out foreclosure avoidance.
Well, remember, it's not a foreclosure. It's a property partition. It's two partners that it's a partner that wants out, but he wants to do partition by sale. He wants to sell the whole property and use a private for-profit referee that's called a court-appointed referee, where it's all BS. He's done $1 billion in assets in LA County. Oh no, not LA County, and up and down the California, $1 billion. So imagine how much, what he's done. This guy.
Oh yeah.
1 billion in assets. How much taxes he paid, I'm not sure, but he definitely, he's definitely doing a railroad mission. If I can get this guy stopped, then I think that would be help a lot of people also, not just me, because he's been doing this.
And you're in Stanley Moss, right?
Yuck. Yes, I am.
Ooh.
Yuck. You remember Richard Fine? Do you remember that guy named Richard Fine? He was
He's been on our thing here. I've known him for a long time. When he was arrested.
I talked to him about this, and he's like, you got to run a cert, and you have to motion for to dismiss. But I'm not. But he says you have to get the defendant's counsel to do that. But the defendant's counsel is playing games and saying, no, the case is already over. So it's two older people. They're 85 years old. They don't know what's going on. One's my dad and one's my uncle. That's that's how, involved this thing is. And,
I'll have to talk to you about it later and stuff like that.
Yes,
'cause
sir.
I gotta do things. Maybe we talk tomorrow with Salam sometime after 12 or something.
Gotcha. I appreciate it.
Okay,
Absolutely.
we'll come
Thank you.
online and talk about that. And see
Okay,
what, what
do I go
options
to-
are available,
Should
okay?
okay, I appreciate it.
Yeah,
So should I sign up in the web, for the website, or should I?
yeah,
should I
just
email
go to
some-
David versus Goliath. Yeah, go to David hyphen and then vs-goliath.org.
Okay, and you're okay with taking on another student?
We want more, the more the merrier to come on here and talk and stuff like that, but what we do is we're gonna talk about this, but we can talk about whatever we need to talk about to help you. We find a way,
I appreciate it.
okay? So, yeah, and then
Okay.
talk to Salam tomorrow and then I'll talk with him, okay? We'll get on the line.
Appreciate it. Thanks very much for all your help.
Yeah, no problem. You know, we got a lot of sharp people on here, the people that have been working, a lot of researchers, Tina,
Well, don't talk bad about me like that.
and yeah.
You're the hardest worker
I
in
didn't mean to
business.
call you Tina.
Is it true that you want to be you're studying to take the bar exam? Is that
That's
Yeah.
my
Yeah.
condolences to him, not me. I'm not.
My condolences.
no. I meant Gavin. Yeah.
Yeah,
that
you
true?
mean Gavin, because I'm not that dumb.
No, you're
I
not.
mean, I didn't mean to say it that way.
I can tell you're not sitting in courtrooms. You're making trouble in courtrooms. I love it. So is that true, Gavin? That you're gonna are you thinking about taking the exam, or is that a secret?
It sounds like it might be kind of hard to do though, it's like, don't you have to be smart to take that sort of
You're
thing?
a very smart guy. You're a very smart guy. The question is, do you have to sell your soul? That's the question.
Yeah.
That's the question.
Yeah, but he don't have no soul, so he'll fit
Oh.
right in.
It fits in.
You have to be a smart guy with no.
You're a very sharp guy, man. It's not about being.
Oh.
It's about whether where your faith where your allegiance lies, right?
Yeah, where your allegiance, where your loyalty lies,
Yeah.
it's his
Yeah.
pocket.
Well, in that case, you're a good candidate. Then you can do it. But
Yeah.
I believe that. As soon as
Kennedy
you see,
says.
Well,
I
he's
believe-
up for it because he heard he had to have one of those prostate examinations first.
Yeah, he said
They
prostate
do that-
is
they-
required.
There's a
Sign
star
me up
chamber.
right away, he said.
Star chamber. But so I mean, I just feel that once you get in that, they're gonna rub you the wrong way, and you're just gonna be, it's gonna be one of those things.
They rub
You
me
know?
the right way, I'll do it.
Yeah.
The wrong way.
Yeah.
No, we just, the thing about this here, all joking aside, is that we've come a long way. Everybody here, because everybody was trying a lot of all the other stuff and methods and stuff. And you really don't get anywhere. We have had success in a lot of things, but what happens when you use an attorney? A lot of times you get your stuff, your rights waived. And I've had times when even we had a good attorney, you just didn't do things or express it the way that needed to be done because he's taken on so many clients that he just goes there. He don't even do the paperwork. He shows up and he asks questions. And sometimes he does really good, and then sometimes he does, doesn't do good at all. So that's why I say that you have to know this on your side. And so whether it be federal or state or criminal or traffic, it's all the same. It's been able to present your evidence and be able to know who you are when you walk inside those courtrooms. You always walk in and you just, you're not like a church mouse. You let them know who you are. Good morning, I'm this, that's. If you're the plaintiff or the defendant. And see, we approach from a different perspective, and the plaintiff too. We have a whole different process. It's totally different than the way that normal people do it, because, I'm like this. It's just mind boggling to me when people would say, okay, where's the plaintiff? The judge would say, well, they don't have to be here until trial because they're represented by an attorney. I said, well, wait a second. I said, you're saying it's okay to rape me today and continue to rape me for 6, 8, 9 months, maybe a year. And then what happens at the end of the year? And you come to me and say, Mr. Mendes, we're going to have to unrape you. And I said, why? It's because we just found out that they didn't have a right to do that to you. Well, shouldn't we have done it the first time when I asked about it? Well,
Sorry.
Yeah. Yeah. But at that
Sorry?
time, it's no good,
Sue me.
Yeah. But see, this is what you have to understand is that you got to stand your ground. You got to stand your ground and challenge that. But most people don't, though.
I think it's amazing. I showed you a little bit of the transcripts that I had. So, it's just a matter of how far that the knowledge that they'll stump people that are brand new, and you kind of gets confused in that whole thing. So,
But
so
you
I'm
won't
glad
when
that-
you're with us. Once
Yeah.
you get that, your confusion is going to start going away. You're going to understand it because there's many different things that the judges say, and we understand. I've been in front of them a lot before, many, many, many times, and not only for myself, but watching other people when I used to be in, and just like Gavin does and Darlene does, they go to these courts and they listen, or they watch them on the YouTube. You listen to what they're doing and you hear what they're saying. So pretty soon, when you hear that enough, that's what they're going to say. Like when I was in a court case in federal, I already knew that. That people heard this story, but I told them, I knew I wasn't a signature on the deed of trust, and that's the first one of the things that the attorney said. Mr. Mena is not a signature on this loan. He's not a part of this action. The judge said, "What do you have to say about that, Mr. Mena?"
No, he's not either.
And I said, "Well, I said if the court will accept and acknowledge that I have no right and title and interest to the bank, see the difference?" Instead of saying, "Neither does he."
Exactly.
See, if the court will accept and acknowledge that I have no right, title, and interest because my signature's on the loan, then I want the court to accept and acknowledge neither does the bank. Their signature's
Amazing.
not there. When I
Exactly
did
right.
that, then the attorney came unglued and started slamming the paper on this. All the facts right here. There's no motion relief. I said, objection. Here's a lacks
I love it.
foundation. I'm going to object him testifying under 601, 602, and 603, Your Honor. Competency to testify, lack first-hand personality, and plus he's failed to swear in.
Well, the guy must have gone crazy, the attorney.
Oh, he
my
stopped,
God.
and the judge made him produce the original note. Told him you have 30 days to produce it, counsel.
Yeah, he
So
dropped
see,
the case.
The thing is that you have to understand is that once you understand this game, you can stand on the merits. I'm not saying that you're going to win every single time, but you can pretty much put them in their place. And we're getting to a point where that's it. We're done. We're going to show you how to build. You've got to go into the courtroom, you do your transcripts like you do, and we're going to show the errors and mistakes that you made so you learn. Other people learn from your mistakes too.
Right.
And so we do as we go there, because I did the same thing when I first got in. First time I went in court, I said, objection, Your Honor. He says, okay, Mr. Counsel, foundation, objection. I said, objection. He said, good try, Mr. Mendez.
Yeah.
He was laughing at me,
Of course. They're like, listen, this guy, he's brand new, whatever it is. But even if you say objection, and you say hearsay, and they say overruled, then you say, well, are you saying that you're denying my objection? You don't agree, and that kind of thing, right? And then at that point, you take it. Where do you go? You go to, it's on record, yeah. You have a record of it, yeah.
Yeah, but
you
what
can
you
take it
do is
to
you
appeals.
ask them certain things. You ask a question now. That will put him in a position that lets the other appellates and other courts know that he abused his discretion, he violated his oath, and he prejudiced you. See, and you tell him that. I said, I said, you could do this to somebody else, but I'm fully aware of what the thing that I raised right now. And I said, you're overruling that. And I'd like the facts and conclusions along why you're doing it. I said, because the statute is very clear. It's not vague and ambiguous. I see there's a difference in the way you have to express it to when you go to the courtrooms and you go to these judges.
Right.
And so you ask him a question like that. Now he's got to come forward and he said, well, I'm not here to give Nev. I said, I'm not asking you to give legal advice. I said, you're a judicial officer and we put you in their public's trust, hoping that you have full knowledge of the law. I understand it. And so therefore I know that you're sidestepping this stuff. You're abusing your discretion and you lose your state immunity under the 11th Amendment doctrine. I said, so I'm just asking a question. Yes or no? You put them in a position, they don't like it. And I've never really had to get that far because I usually got my way when I started objecting to attorneys and things like that,
Yeah, you got them right on their heels as soon as you get in there.
Absolutely. Right as from the get-go.
Yeah, that's the way to do it. Of course, it comes with experience, right? So it took trial and error for you, right? And you're giving us the secrets, which is great,
But I learned from when I happened to do too much trial and error, but there was trials and a few errors, and because when I would ask something, I said, I'd ask something that he's asked me, excuse me, Mr. Mena, are you making the mortgage payment? I said, objection. Are you asking a discovery question for the plaintiff? Oh, I'm just trying to find out about the case. I said, well, isn't that what he's paid for? Counsel? And I go in and ask him things like that. But
then then the counsel asks you that question. Is that what you're saying?
No, the attorney has to respond. But he can't because he's already been objected to. So it put him in a position. That's why they would walk off the bench and then move for a continuance.
They'll cry. Do you suggest always going down to the actual courthouse as opposed to doing like a Zoom thing?
Yeah, absolutely. Because
Scary.
Zoom, they can do whatever they want to do. When you're in front of them, you got in front of everybody like that. It's on the record. Yeah.
Yeah, they shut you off. They shut off your mic when you're in Zoom.
Yes, they can shut you down in a heartbeat.
Oh yes, it happened to me.
Yeah.
It happened to me. Yeah.
Right.
Okay. Yeah, that's awesome.
Yeah. We know we've been at this too long. So we got a lot of people going to court hearing stuff like that. And Lena, I don't know if she's still on here, but Lena did really good. She's gone into court and she's doing her own thing now. She's doing pretty good in court.
Is that the Lena that does the land patent kind of thing? Is that the same Lena? She with the property that she
No.
secured a property? No.
No. This is Lena Hanoan or something like that.
Mhm.
She went to sleep.
So is a lot of property, a lot of foreclosures in this
Oh, there's
in
a
this group?
ton and tons of foreclosure, man.
It's unbelievable what they're doing. I mean, they're stealing the properties from people. As
They
you know.
don't have a right to do what they're doing at all because all these houses were free and clear. What
They're
it is,
thieves.
they're
They're
using
thieves.
title companies, trustee companies working together, creating these false documents, to make it appear as if they had a right to be able to take your property. That's all.
Exactly, and they're photoshopping, right? You saw that, right? I'm not
They
just
do
crazy.
photo, they do scan, they do everything.
I'm not just crazy, right? I'm not just crazy.
Ah. Oh,
Yeah,
you are
okay.
crazy, but that's still the truth, though.
That is true. Somebody must have been talking to you.
Yeah.
But they're photo. I mean, it's in my mind. I mean, I could see it, and like I'm like, and it's like it's all crooked, and it's not even the same. It's not even it's like unbelievable. They walk around with an order that the order doesn't even have the right date. The judge wasn't even on the case then. I mean, like, and they just walk around. Oh, this is what I have, and everybody has to listen to me because I'm a court receiver, and I have a jacket with a court receiver on, and that means making legit. And they came into the property with security guards with guns into apartments, breaking in doors with guns. I have on video, guns drawn out. I called the sheriff. What's going on? Salem was on the phone because I messaged him. He's like, give me a call. I'm like, yeah, they're doing it right now. He's like, give me a call. I call him up. He's like, I call the sheriff. The sheriff's like, yeah, we're gonna call 5150 on you because we don't see anybody with guns. I'm like, what? I have a video of him. I'm right here. It's just, they're all.
Who brought guns on? Who?
This court receiver. His name is the receiver for the property. The court appointed this receiver. The receiver hires a security guard team with 6 security guards dressed in tactical, like whatever, with guns, and they broke into places, units to take possession, and they put the gun out. Their gun was out.
They broke into your house?
No, an apartment complex. Like they broke in people's apartments. Yeah, with no warning. No, like notice, 24-hour notice. None of that. They do
Did
whatever.
they have a
in LA.
warrant?
No. And I told the sheriffs. They go, oh, you were noticed. I said, no, I wasn't. Nobody was noticed. So they're like covering for them. It's like amazing. It's the biggest. It's a robbery.
Share the video. Where's the video at?
Okay. I'll do it right now. Yeah. Okay.
Post it in the chat.
Yeah, it's the most unbelievable thing I've ever.
Share it on the screen, man. That's important, dude. You got a video of people breaking in the doors without a warrant?
with gun and waving their guns.
Share that video.
I'm doing it right now. Yeah.
Please.
Okay. No. Yeah. Okay. Here, I'll do it right now.
Was that in your house?
No,
Whose house were they going into?
It's in my apartment complex, but it was another
Another tenant?
Another tenant, yeah. He was out of town. And he had one of those cameras, Let's see, manage. I'm trying to manage the photos.
Can you share your screen?
Yeah, I didn't know how to do it, but okay. If I can just, I'm just going to put the video inside the chat. If that was the here, show selected. So I selected this. I guess I can. Okay, this is it. Done. Okay. Is there a way to share the screen?
Yeah, press the green button on the bottom. Share screen.
Okay.
Are you on a phone or desktop?
I'm on a phone, so let me just do that. Oh yeah, share. Okay, here we go. Share. Okay.
I gotta see this.
Yeah.
Huckleberry breaking in the doors with his mask, ski mask. Is he wearing the ski mask and everything? And what?
No. They have the old. Let's see if I can get this without.
Common burglary. Is this just a crime taking place? Huh?
Yeah. So so it's saying it's sharing, but I don't know if it's screen broadcast. Zoom. Okay.
Right now I'm seeing broadcast. So I'm just seeing broadcast. Yeah, there you go.
Okay, so let's see if I can get to without looking at.
Make sure you share the audio too. You might need to click audio.
Right. Let me
share audio as well.
Okay, let's see where I got. Okay, that's probably not the one.
I want to see if maybe Richard knows any of these clowns. Maybe it was one of his one of his cousins.
Let's see. Let's see if I can get the. it's
Were they
gonna be-
wearing ski masks?
No, but you get there. No, no. Here it goes. Watch this. Look at that. They broke in already.
Sure.
Look at who are these guys? They're real. Look at the guns. Why are the guns out? Why are their guns
Those
out?
police officers?
No. Look, the gun's out. Look at the gun. You see the gun? Right there. The
Yeah.
gun.
Yeah,
Who does that? And what world do we live in?
3/2/2022.
Look at the gun. Why is the gun out? Who is this guy? Who is this guy?
Whose
I mean,
apartment
really.
is that?
The neighbors. It's a
What were they
Unreal.
doing there?
they're taking possession. They're trying to take over the property.
Breaking in?
Break it in with no notice. I called the police. They didn't give a shit.
Wait a second.
Yeah,
Somebody
I'm
broke into the house.
No, it's an apartment complex. So they have more than one unit, right? One of the units.
That looks like a break-in.
That it was a break-in, but one of the units, not the. It was one unit. It was like one of the units was broken into. That guy, and he did it to more. He did it to other ones. This is the only one that had a camera in there.
What happened when he broke in there? What did he do next?
He pulled the camera plug out. But what do you mean? What did he do next? They changed the locks on the doors and they put new locks. So the guy comes back home. He's like, I'm like, what the hell's going on over here? So we changed the lock back for him. It's like a fight between us. It's like a little. It's like he attacks it. It's like it's a war almost. I hate to say it.
So that guy, he comes in there, he sees you're being filmed and he shuts the camera off.
Shuts the camera off, right? And then they change the locks on the door, and then they walk away, and they walk.
And then the tenant comes back and the locks are changed.
Locks are changed, and I have to change it back.
Was he behind on his rent?
Who gives a shit what he was? He wasn't. But he's. I mean, at the end of the day,
Well,
I mean,
no,
at the end of the day, you have to-
it like, I mean, if he wasn't behind on his rent, it's even better. That's why I'm saying,
right? Whatever.
I
I mean,
mean-
yeah. I mean, he has to give a notice, right? They have to give a 24 hour if they want to enter. They can't just do that. There's rules. This is not the Wild
what
West.
if he
with
was in
guns.
there with his wife and doing something private? I mean,
What if he had a gun behind the door and there was a shootout? How about that?
right? Yeah,
Yeah.
that guy could be at risk.
It's a very big risk. I mean, he's a court referee. That's what they do in court. So then, why did you bring the law with you? Why did you bring
Have
the
they
security
done
guard?
that to you?
No, because I told him I practice. I believe in the Second Amendment.
Oh my gosh, you actually believe in the Constitution? What are you? a
Right, and the
terrorist?
Second Amendment. Yeah. Forget about the jury trial. I'm talking about the Second Amendment. So at the end of the day, it's like,
So you mean you actually believe in the law?
I mean, I thought we were governed by that, but what I'm realizing now is that they make the law and there's no consequences unless you I guess unless you go up to the top route. You talk about filing a bar complaint. You know how many bar complaints I filed? Well, they don't give a shit. Deny.
Well,
They know
you're
me by
dealing
name
with
at the mosque. At Stanley Mosque, they know me by name.
So you're dealing with a guy that is a $1 billion property owner. Is that what you said?
No. He no, this is the best. He works for he has a business called Court Receivership. Okay, receivership specialist. He's done 400 cases in LA in California that give him the right to come in there and become his own lawyer. Okay, so he's allowed to file paperwork, and then when you try to sue him, he has immunity, so he gets everything denied every night. Now this is what I think is even more interesting. There was a judge before him, before this judge that is now on, and as soon as this referee was in the process, a new judge all of a sudden appeared, and this guy named Maurice Leitner comes in, and that was what has happened. And of course, I didn't know anything about nothing, so it confused me. So I went and looked for the paperwork, but of course, the paperwork is not found on the where the judge came in. A notice of rehearing. None of that. You can't download that. It's unavailable. So it's so much corruption that's why I brought up the whole article courts, and of course I hear what you're saying with regards to step away from that, but I just feel that you're playing in their court, in their game, and they're going to make up rules as they go. And in my situation, because there's no rules in this. This is lawlessness. They did this twice. Okay, I changed the locks once for them, and they did it again. I have another video of the other guy doing it again with guns again. I have another video. Two videos.
So they did that to your neighbor
twice, and they did it to other neighbors too. And the other neighbor just left. I have 3 people that moved out. That was it. They're done. And so I'm taking a loss. We're taking a big loss, right? I have three tenants that are gone because of this. I can't rent another place because they locked the business bank account. They called Bank of America and they put a hold on the account, so our business account was locked. And when I filed an appeal, I put a stay on it. they continued and they drained the account as we put money in the account. They were draining it. And they just say that they're court appointed referees. That's what I'm court reported. Okay, great. You have to listen to me. What? What do you mean? Because you're a court, what does that mean? Oh, because you have you say, I can say I'm a court reporter too, a court receiver too. Who's going to verify it? It's just, it's basically who has the strongest, hand. And it's the thing for me is, it's 9/10 of the law is possession, right? 9/10, right? And the other 10th is a claim, right?
Wow.
So, right. And that's what I'm trying to do. What I did is between us two and the rest of the world that's listening is
Why?
I stacked a new 10. I stacked new, people into the units. I just filled the units with people that I know. Fuck it, let's do it. Excuse my language. If you want to play that game, let's play that game.
What's,
Sorry, guys.
come on.
My
don't
apologies.
argue, okay?
Sorry. I guess I just get a little bit emotional, as you see. I'm sorry, and I apologize for the cursing and stuff. Did I offend anybody? Is that what did happen? Maybe.
No, I was talking to one of my daughters.
Oh, my bad. Oh, sorry. I thought it was. I'm sorry. I thought it was offended you. Yeah. So it's just basically. So what I do, what they come in there, they change the locks, right? They get a security guard, like 6 of them come in. They have a locksmith. They go change the locks, and then they leave because I'm on property. I go ahead and change the locks back. Now, when I don't change the locks, then by accident one of the keys gets snapped in the door, so they can't show the units. So it's one of those things. I don't know how that happens, but for some reason, the keys don't fit in. They just snap in the door. So they have to call the locks. Of course, they're billing the property, right? So my contract is with all these tenants, right? So I said to the tenants, guys, you have a contract with me. You want to change your contract, and you think you're allowed to go in. If you think you can supersede a contract with a verbal or a piece of paper that says that they can do X, Y, and Z, you still have a contract. You're still liable to hold, to follow through with your contract. And when this shit goes down, kind of gets, we get, this all blows over, you still have that contract, you're still liable for it. So might as well just continue paying us the way you're supposed to do it, and then we go from there. So some of them decided to, some of them decided to leave, and the other ones are still paying. But it's
So are you so what is your position? Are you guys the owner or the manager?
right. So I own 50%. Me, my brother, and my sister own 50% of the property. And I was managing this property for maybe 15 years. So I was on, I was the one who was writing all the leases. So when you talk about leases, I can, I have leases. So anytime, I bring people in, I can just write a lease. But now, of course, now they're coming in and out of the unit, into the property back and forth in the past couple of weeks. So it's been a little more difficult to kind of, to control the property, because I'm trying to fight this case and also trying to, to save my situation by my home, because I live here, right? So it's one of those things. It's a lot of work, a lot of, it's a lot of energy, I guess you'd say.
Yeah, but who is this guy that's trying to do all
His name
this?
is
What's
Kevin
his
Singer.
position?
Kevin Singer is on the line. It's called, you can look at him, you can type in Kevin Singer fraud, and you'll find maybe 15 cases. Kevin Singer fraud, or Kevin Singer, or
So what's he hired to do?
he's hired by the court, apparently, to be the court referee or court receiver, to sell the property, to come in and to manage and sell the property. So there's a proposed order that was made after I had ownership of interest in the property. After the judge, I came into the court to make a claim of my property. After the judge, I motioned to intervene, which was just before, just after they put this interlocutory judgment. But it was way after I already had interest, and way after I made a claim. But of course, the judge, wants to kind of like, not hear my side. Tells me to have to intervene the proper way. I've intervened the proper way, and he denies it. So it's one of those things. It's like they're trying to just hush me down, blow me up, push me to the side.
Who wants to sell the house?
Oh, the other partner. No, not the house. The apartment complex. It's two 8-unit apartment complexes in West Hollywood. 8 and 8. 2 different properties. So the easiest partition would be, you take one property, you old putz, and we'll take the other property. You don't want to? You want us to buy you out? We'll buy you out appraisal. We got 2 appraisals. You don't want it? What do you want? Oh, you want to sell the property? Okay. You want to sell your share? Sell your share. Don't force me to sell. Who are you to force me to sell? Oh, the court's forcing me to sell. Okay. Oh, so we're going to get a private for-profit receiver to come in there and decide who's getting what? No. There's something wrong with that. We're now, the game is on, so let's do it, you know? I mean, it
What
goes
about
I
this
mean,
guy who wants to sell? That's your your partner?
it's better than that. It's my effing uncle. How's
Your
that sound?
uncle wants to sell the house.
How's that for,
or the
how's that?
place.
Hey, let me get a little better. He has no children. How's that sound? Is that good? Well, let me
Now,
get
are
it.
you,
Yeah, go ahead.
does your uncle hate you?
No, but he just likes his mainland Chinese girlfriend, I guess. That's what I'm telling you.
Huh.
Yeah, he has a girlfriend that's
He wants-
liquidating. He has a girlfriend that's liquidating his assets. He had properties, and she's just liquidating him. Yeah, she's a younger lady, and
Girlfriend?
she's liquidating him.
Girlfriend?
He's
What do you mean?
85. Huh?
Oh, he's 85. Is
Yeah, yeah.
he in a
He doesn't know
hospital
left
or
from right. He doesn't know
something?
left from right. He can't see. He doesn't know left from right. He doesn't know what's going on.
He's blind.
Yeah, he's blind. I can't see. I'm like, well, then don't sign shit you can't see. So Sophia tells me it's okay. Yeah, okay, yeah, right. Yeah. So it was my
What?
promise to leave. It was my promise to your grandparents that you guys are keeping the property. Yeah, but you filed a partition action. Yeah, because I want out. I said, yeah. So then let us buy. It's a mess. It's like talking. You know, I don't know if you've ever dealt with somebody that's kind of like in their age, that they kind of like, you know, one day is this, one day is that. He doesn't realize what's going on, and it's elderly abuse. You know?
That's called, yeah, they have protection for that. You're not supposed to, yeah, what is that?
Yeah. It's elder abuse. It's elder abuse. Yeah, it's abuse. It's financial abuse, elder abuse, and you know, and they did that to my father too. My father's 88. And I told my father, I said, your lawyer is lying to you. You understand that there's a case going on? No. My lawyer said the case is over. I said, over? Then what are these files? Well, they said it's just the process. I said, that's process. It's called court. That's the process. It's called hearings. That's what's called. That means the case is still active. Well, he doesn't. I said, tell him to motion to dismiss this case already. He doesn't. You have no interest in this property. You're done. You don't need it. It's not yours. You know, it's over. You don't have to.
And he died? He died all
No,
of
my
a
dad.
sudden after that?
My dad's alive.
Oh, he's alive.
My dad's alive. So my mother passed away. When my mother passed away during this situation, the property was transferred into me, my brother, and my sister's name. The interest, right? So we have the 50% of my mother's, right? You know, while we had this interest, the judge goes ahead and even though we motioned and we did the whole thing, goes ahead and still gets his court signs off, stamps, or his assistant stamps this proposed order that was crossed out. No more proposed because it's crossed out. I mean, come on. I mean, why should we make our own order? We could just cross out the proposed part. And the date's wrong. Leave the date that way. It doesn't matter. Let's just stamp it. Because stamping means it's legitimate, right? That's what you do. You just stamp something and then it becomes legitimate. Forget about a notary. Forget about a wedding. Stamp it. And then the guy's walking around with a stamp thing. Oh, that's it. Where's the warrant? Where's the order? Oh, well, this is it. Oh, yeah, this is it. That's a piece of paper. I have 3 orders. I can do the same thing. I was doing that in high school to pass you know, for my high school test. You know, that's what we did. You know, cut and paste. We could do that. It's very simple. But you know, they're getting away with it because they have this jacket, and that was my key. I should have bought a jacket and embroidered court owner or something like that, because these guys are court receiver walking around with a jacket. Oh, this is who I am. Yeah, it's amazing.
So they want to sell the house, sell the place, the apartment building, and then
Yeah.
when they sell it, do you get any of that money?
If this private receiver decides to, if he doesn't decide to, what do? I say, no, don't take my money. Oh, let me get back some money. Oh, okay, yeah. The judge, you have to help me. No, the judge's not helping me. If I let this go to sale, if I don't stop it now, it's going to sale, and the receiver is gonna say, yeah, you know what, you get this amount, and then this guy gets this amount, and I only get $275 an hour. Don't worry, I'm very happy with it. You're selling the property for $5 million. Just give me $275 an hour. How's that sound? Yeah, right. The guy has the management company. He's getting action on. He's getting action on the sale. On the broker. He's getting action on. He's getting action on from the lawyer, from the plaintiff's lawyer. You know, everybody's getting action. They're all taking the action. You know, they've done this many times. You know, everybody's getting a piece of action. The judge is for sure, something's happening with the judge. Like either that he's getting, you know, some sort of donation to something, or you know, something's going on there. 450 cases. 450 cases like this guy's doing. I mean, like it's not his first rodeo.
You mean that guy who you said was running a scam?
Yep, receivership specialist. That's the website. Yeah, and he you know, he has a whole crew. And they come in there, and he's done, you know. Just type in Kevin Singer fraud, and you'll see what a crazy. I mean, You know, he writes his own motions as he's not a lawyer. He's not a lawyer. He just writes, you know, he just files stuff.
Oh, he's
as
not a
court-
lawyer?
No, he's not a lawyer. He hires a lawyer. He asks the court to hire a lawyer, but he doesn't hire one lawyer. He hires 3 lawyers, and they each get $500 an hour, and they try to bill you for it. It's amazing. It's amazing, and they think, and people are paying for it because I mean, I guess the court has the thing is the court has the paper that controls these guys with guns, the legitimate guns with the sheriffs, and then you're stuck, right? Right now, we can fight the guys that are not legitimate. So the guys that have the biggest gang is the sheriffs or the LAPD or whatever it is. You know, I mean, those are the guys you can't win. You know, because they have bigger guns than you do. You know,
Oh, yeah.
I mean, I hate to say it, but
They got
And-
big guns.
Yeah.
You want them on
They-
your side.
yeah, they got a big team. They got a big team, and you know, they can take you out, and you could just, you know, just say,
Well, that's why you want them on your side. You know what I mean? You want to move, that's the executive branch. You want them working for you. You got to move that court, make that executive branch work for you.
exactly. But remember, the executive branch is not what we're moving, right? We're trying to move the judicial, but we're not in the judicial court. We're in a legislative court.
You don't get to the executive branch until you move the judicial branch to make an order.
But you can't get to judicial unless you move the legislative court. That's where you're in.
Well, we'll call it legislative or judicial. Once you move the court and the court makes the order, now the executive branch becomes yours. Now the
Right.
executive branch is working for you.
Right. And how do you move a court where the judge is on the same team as the attorneys, who's on the same team as they're all in the same, like, why would they move you? Why would they allow you to move the court?
Because they're under the authority of the
Of
higher
who?
court above them. And
Which
once
is
they-
what? The appeal?
Court of Appeals, yeah, no.
Okay,
it's
but that's the same.
what
That's the same branch. Same branch.
It doesn't, no, it's the.
No, same branch.
Remember, it's the annotated code, the controlling authorities.
Okay.
They're controlled by the authorities.
The authority of their own legislative court, right?
Remember, they're running a business. Okay,
Oh, there you
so
go. Mhm.
they're running a business, and you're walking into, you know, a franchise of a business.
Right. And you're
That
trying to.
business, you got to realize you're trying to talk about something that maybe doesn't apply to them. They
No.
have
You're trying to stop them from
business-
controlling business. You're trying to stop them from making
Right,
business, right?
you're trying to stop them from making business.
Right,
So,
and that- and-
but in
yeah.
their business, their business has rules to follow. The business has to follow rules because
Okay.
there are other people up the business who are more powerful than them that will be affected if those businesses are not followed with. So therefore, they got to say, "Oh shoot, the CEO of this business has rules I got to follow." And therefore, if I'm not following those authorities from my boss, I'll get fired. Okay.
Fire, or this guy doesn't know the rules and doesn't know how to get to the boss, and I'm just gonna hush him down and get him out of here.
Yeah, that's what normally will happen. Exactly.
Right. And so you're saying that in order to get to the boss, you have to. Where's
gotta
the
know
boss
the-
located?
It's
You
in
see-
the annotated code.
No. I mean the boss. Where does that guy like where's that court?
In the annotated code.
That's the same court though, right?
The annotated code is not the court, it's the controlling authority.
But it's controlling authority in the legislative court. I'm talking about that's not the person that's not the boss, right? That's just the way to control, right? But who's the
The
actual?
court,
Who's the one?
they're bound by the controlling authority. That's their boss.
Right, they're bound by it. But if they decide to be not bound about it,
No, they won't.
okay. Well, I'm gonna send you my appeal that I made that shows the case law that they didn't want to continue the case law because there was another revision in 1973 that went on and talked about interlocutory judgment. Even after they said my case wasn't timely, my intervention wasn't timely. Even you can do an intervention even past a judgment. You can intervene. Not forget about interlocutory
Really?
judgment. Yeah, even after.
You mean a motion to intervene?
Correct. You can intervene even after not just an interlocutory judgment, not even an order. After a judgment, you can do it. And I cited as a court case law. And they said-
I know you can because I remember because Salam actually did an intervention in a case I was in. I remember specifically that he filed a motion to intervene in a case.
Yeah.
And recused the judge.
Beautiful.
McGuire was recused. This
Beautiful.
is the whole reason he intervened in the case at
And
it was very technical, highly technical.
Yep.
Now I'm not gonna review all that. That's way out of my league, but I'm
I
saying
understand.
that
I did a peremptory
so you don't
challenge.
need to send it to me, but exactly, that's exactly what Salam did. He
Yes, that's what I
intervened in
did.
the
That's what I did.
case. He did a preemptory challenge under 170.6. And
Yep.
when he filed that challenge, I have the transcript and I have the recording of Judge McGuire. And
Awesome.
he breaks it down. He's like, I can't believe what just happened. This
Shit.
random guy just appeared in the case and
Yep.
recused me from the bench. I have to recuse. Here's the case law. I'm
Und-
screwed.
Oh
I'm
my
out.
gosh, that's amazing. Amazing.
Salam did it.
Yeah, and that's what I try to do. And I did a peremptory challenge on him, and I did a peremptory challenge on the referee. They go, oh no, you're not a party to the case. That's what they said. You're not a party
You
to the case.
didn't do it right then.
What do you mean? I wasn't a part of the case. What was I supposed to say?
Well, Salam did it right. It worked.
Okay.
I helped him with it and it worked. But
That's
you know,
awesome.
whatever you
Was it a
did,
different judge? Or
obviously,
was it the same judge as I had?
Judge McGuire was the one that
Yep,
we
I
had.
have a different judge, so maybe that judge was,
No,
was
it's
more
it's
legit.
not. It's just technical. It's just
Okay.
technical.
I mean,
It's
yeah.
very technical on that. You have to meet a provision in the I had to break down.
Yeah.
I had to read the annotated code, excuse me, on that. So
That's great.
excuse me,
So
tight,
the
and
judge.
finally to figure it out. Salam really did a great job. He appeared at the hearing, and what happened? Let me finish. You're jumping on me, and I you know you have a habit of
Yep,
just
I
cutting in
apologize.
and saying, oh yeah, and this and that, and that. But in order to have a conversation, you know,
Forgive me.
it's like we're not in person. If we're in person, it's easier but we're on a thing like this. It's like hard because people are talking over each other. You know, in person is you can easily do that and it totally works. But yeah, so with Salam, what he did was he appeared in the case and literally filed this 170.6 challenge. Judge McGuire was the judge, and I had challenged Judge McGuire. This is vindicating for me because I had done a recusal on Judge McGuire. He answered my recusal in the 170.3, and I couldn't get him off the case. So I then filed a writ. I filed a writ, you know, and Judge McGuire, you know, he says, I go in to stay the case. And Judge McGuire, he's like, oh no, I'm staying on this case. You know, I'll stay the case. I'll let you file with the Court of Appeal. I filed the writ to the Court of Appeal. Turned out that even though it says when you file the writ to the Court of Appeal, that's not the proper case. It should have gone to the appellate division because I was in a limited civil court. And so at that point, the writ came back denied. I filed it with the appellate division. It was past the 10-day timeline. I lost the writ, even though I believe would have won. I had all the facts in the law. That was past the timeline. Then at that point, Judge McGuire continued on. I lost the case at trial, at summary judgment. Salam comes in 3 or 4 months later and intervenes in the case. And it was a special procedure. It was at that point, it was a gosh, was it a CP10 or, you know, it was a CP10, I think, that he filed to intervene in the case as a claimant. And with the CP10 form, that CP10 form gave him the ability to come in, and then on his first motion, that's what it was. He filed the CP10, the judge let him come in. Then on his first motion, which was a demur, with the demur, he filed the disqualification motion. And that was an intervention. It was an intervention. And because I had never used my 170.6 preemptory challenge, the judge recused. Automatically, he was done and he was off the case. And we had to get a new judge. And we got a brand new judge who'd never heard a case before, just out of, he was the mayor of Davis.
Mhm.
And he all of a sudden became the judge. Walk, brand
How'd
new
that go?
judge. He couldn't believe it.
How'd it go?
He was the most careful. He was walking on eggshells, dude. It was like this guy was so careful. Everything was slow, dude. It went great because I felt that he took everything under consideration. Every single thing was carefully done. I mean, I can't say that I didn't get my chance. He did everything equitably. You know, there was a few mistakes that could have been done better on our part. I had hired an attorney at that point to go and represent people, and
Mhm.
had I brought in a couple of other little angles, I think I could have won at the hearing. But I felt the judge did a great job. He actually did a great job. He was awesome.
Oh,
You know?
you know,
And I'm saying I lost.
Yeah.
And I thought he did a great job. I'm being honest. You know, I'm being fair. I feel like he really weighed the facts in the law. He didn't just make a bootstrap decision. You know, I mean, he heard everything. And in hindsight, which is always a better angle because here I'm looking at it now, you know, looking back at it now. At the time, sure, of course I wanted to win. I always want to win, but it doesn't mean that the judge was wrong. No, he wasn't, because I didn't appeal. He was wrong, I would have appealed. No, he was probably made the right decision at the time.
Yeah.
You know?
You know, I'm sorry to interrupt you. You said something
No,
about
go
the
ahead.
663, you know, you mentioned that. And I just wanted to let you know that that was one of the motions that we went for. We provided citations to 14 statutes support. This is for the minute order, that are as support for their request to set aside the judgment, but they do not show a basis for relief under any of them. For example, they cite CCP 473, but they do not cite they don't specify a subdivision or explain how the section authorizes the court to set aside a settlement. Similarly, moving parties cite CCP 387, 473, 657, 659, 660, 662, 663, and 1008 to support their request to set aside resulting judgment, but they do not show they have met the requirements of any of the cited statutes. Moving parties have not shown the judgment should be set aside. The motions to set aside the judgment are denied. Remove referee. The moving parties ask the court to remove the referee.
Well,
Yeah,
if you've
appointed-
already got a motion to set aside denied.
Yeah.
what
It was
else
all the
is
same. It was all the same. It was three things. We were
When was
motioning
this?
when I filed the intervention the same time. And May 25th, 2021, I filed. It was the request to intervene post judgment is denied. It was, you know.
It's way over my head, buddy.
I understand.
That's
I
like,
just wanted to
yeah.
I just wanted to read it. I just wanted to tell you about it. Just you know.
Yeah, those
Um,
are all blended together. I mean, you only have one ground to bring the motion. You can't bring it
Wh- wh-
under all of them at once. Those are different motions.
Well,
So,
Oh,
you know,
okay.
had you brought it under 473, is it 473D? Is it 473 3.5? You know, what's the grounds? You would have had this, or 663. 663 is a different type of vacate instead of for a new trial. So, you know, 1008 is motion for reconsideration. You want to
Mhm.
reconsider something. All those at once, it doesn't apply. The court
Okay.
is not moved. The court
Yeah, I
doesn't have
didn't know.
legislative authority. The court needs legislative authority to do anything. And so the
Yeah.
key, that gives the court the key to operate.
I see. Yeah, I didn't know. I had an attorney, and that's what, you know, and that's what we talked about. We talked
Wow.
about prep. You
He
know.
really screwed that up.
Yeah, he did. I think so. I mean, you know, I don't know why he did it if he did it on purpose or he did it because he didn't know. But
He must not have known what he was doing. That sounds terrible.
I mean, I thought it was pretty hardcore that he would go in like that. You know, I thought it was like we're gonna knock him out.
I mean, how would the court needs authority to move, and you have to. It can only hear one motion at a time. It's going to hear all these motions at one time.
Well,
In one pleading.
what it was is we motioned to intervene, and then we brought the set aside and all that, which I thought it was not a good move either. At the end, when I said, well, why are we going through to set aside? We should attack him slow, get an intervention, then we should move.
You should
But,
ask Lamb how about the intervention that he did that we won, and he got Judge McGuire recused, dude.
That's
You
crazy.
should ask him. He probably forgot
sure
about
will.
this. He's
I
gonna
sure will.
laugh. He's gonna laugh. He's gonna be like, "Oh my gosh, that's right, dude." I will find. I will find the transcript. I have the transcript. I probably have the recording of that. I'm sure I do. I mean, he's gonna laugh. He was at my house, and you know, I remember being, I was like, oh man, I was like, watch, I was like, let him sit in my office. I was like, let me not bother him. This is gonna be intense. And he goes in there and he wins, dude. It was like such a huge victory when he came in
That's great.
and won this hearing. And he's just like, we high five.
I mean, that's great.
Dude. He
That's
came
great.
in, Judge McGuire gone. Fired
What a
from
great
the
feeling,
case. I mean,
you
it
know?
was like such a victory. I had worked on this judge for like 6 months. I was like, I can't get a fair hearing in front of this judge. There's no way I'm going to win. He hates me. You know, I had burnt every angle with this guy. There was no way he was going to give me a chance.
So did you
Right.
give
And
him
so
the-
when that happened, I was such a massive momentum swing. No, did I win the
Awesome.
war? No, but it was a part of the battle. I won that fight that day.
You knocked him
It was
out. You knocked him out. You knocked him out. You
I
knocked
knocked
his,
him out, and it was a big
great.
win in the fight. You know, I didn't win the war, but I won
It's
that
okay.
fight that day.
Some,
and
you know,
that's
yeah,
okay.
exactly. Sometimes that gives you enough energy to go on to continue. You know, how did you get Salem to be involved in the case though? What was his right to intervene?
CP10 form.
CP10 form, you say, right?
Mhm.
And I'll look that up,
That's automatic intervention.
but how did you give Salem the okay to do it? I mean, like, did you give him part of the, did you write it into the deed or something?
Ask him.
Okay. Oh, well. That's great. Thanks, man.
Yeah. The CP10 form is the one, and that might be a form you might not need to use.
I think so. I think so. I mean, I mean, if they're saying that I'm a party to the case, and I've been, I should go ahead and do this one.
I don't know,
What-
maybe, I mean, that's how we did it and it's at work,
And
CP10.
what was the right of what was the right of the possession? What was the, because that's what I mean, it
That
seems
was
right.
it, just right to possession.
Huh. Sometimes at the end of the day, it's right in front of your eyes, and you're like, that's crazy. Okay, thank you very much. I mean,
I think that's your only hope is a CP10.
oh, come on, really?
Yeah, because if you're already past judgment, that's all you can do.
But they're asking for writ of possession themselves. That's what they're looking for.
Exactly. Once they have the writ, there's no other remedy other than that.
Once they have the writ, I think I can do the prohibition, right?
There's no other remedy other than the CP10 once they have the writ
Gotcha.
in
So
their legislative scheme.
okay, so
Right?
that's
I'm
what they're
saying
going
that all
for.
the other stuff is not, they're always gonna say, no, you always have a remedy. They have to leave you one remedy, and the remedy is CP10.
And how is it how am I supposed to utilize it?
Read the form.
Yeah, right. Okay. So it says, so I'm reading it now. It says,
You give that form to the sheriff.
just hand it to the sheriff.
Mhm.
How come you're holding this? Why were you holding this? This is great information. Thank you. Let me know where I can, if you have the PayPal set up so I can set that up.
Oh,
Or
my
if
PayPal?
you say again?
Oh, yeah.
Yeah, just so I can, I can set something up. So I take this form and I would give it to the sheriff, but I would also enter it into the docket.
No,
and
you
hopefully
don't. Read page 2. Do not
Page
hand
2.
this to the court. It says on page 2, do not give this to the court. It says that right on there. Most people do that and they lose because they,
Do not take the copy of this claim to the court unless you have first given the
Right.
form to the sheriff.
see, do not go to the court with this.
Thank you, sir. Well, thank you very much. And that's okay. Thank you very much.
So you can actually go ahead of time. Now, you could actually wait till the last minute. That's kind of risky, but I mean, what the Lamb did is I remember because we actually have the recording. See, we went down to the sheriff together and I actually
Yes.
recorded the hearing. He made buddies with the lieutenant down there, and he and the lieutenant were best buddies by the end of the day because the lieutenant's there screening people, making sure they're not like squatters or frauds or whatever. You know what I mean? So
Yeah,
he
yeah.
met with him. He's like, "No, dude, I'm not a fraud. Here, I'm a real person. Here's my ID, all this stuff. You know what I mean? This isn't a scam, and the lieutenant's like, okay, let me make sure this isn't some sort of a scam. And he investigated everything. Okay, this is legitimate. And, this is obviously not a fraud. And so the lieutenant did the whole thing and pulled him out. Oh, yeah, this is legit. He took the form in, signed it. And then that's when Salam did the intervention, the
Awesome.
disqualification.
Who signed it? You saying the sheriff signed it?
The lieutenant, yeah.
Wow. Oh man, so let me
Look at the form. Who it's signed by? The sheriff.
Yep. It says signature of the claimant, but also of the claimant, and then it also says the deputy,
officer.
the department.
Yeah.
Wow.
Yeah, you just go into your
West
local
Hollywood.
sheriff beforehand, because before they come and break in the doors, just
Oh,
do
yeah.
that. That will then give you your day in court.
You
don't
said
know.
that. Sorry.
Well,
You said that
I mean,
will give you a day in the court. You said.
that intervenes you into the case.
Right. Right. It says you must
You're
act
gonna
at
have a
once.
right. You have to be heard at that point.
Right. Especially with this claim of right of possession. That's what I'm looking for. I'm looking for the right. I have 9/10 of the law. Right, 9/10 is possession, but I don't have
a
the
right to possession, and you didn't
right.
have
I
the
just don't have
right
a claim.
procedure. Now you do.
That's it. This is the
Claim.
key. This is the key. Thank you.
Like I said, that's the only remedy you have. There's no other remedy. I told Salam that when you called me originally, but I said he's only got one remedy, nobody will listen to me. And I said that immediately. I said, you need to call.
Well,
CPTN."
you said
"Oh,
that on the room last
no,
time?
no, Salam called me about your thing and I told him
Oh.
that, but I mean, and I didn't remember, Salam, if he's doing a lot of stuff. He didn't remember
Right.
it. I didn't think about it at the time, that was how he won in the case I was in, I
That's great.
forgot. But now you should
thank
ask
you.
him because he will remember now, once you tell him about the Judge McGuire, he will remember that. Now,
Yeah.
it's like, oh my God, yeah, I did that
You're
with Judge
right. I mean, I'm
McGuire.
sure he's probably full of different cases you guys are doing
Right,
so much stuff.
exactly. So he doesn't remember, but this was one he was in. He was the guy. He went to the sheriff himself. He went to the courtroom. He won. He'll remember that. He will remember how he did it. Yeah, I mean, that's what he uses, the CP10 form. And
I'm telling you,
got
I
in
was sitting down and I was thinking to myself, the sheriffs have to protect me. I just didn't know how to do it. And I'm trying to figure out, and I read the whole sheriff's handbook. I went through the sheriff's handbook and I'm trying to find out how they're going to protect me because I believe, and I have this document that I prepared that said that, I live on the property and all that stuff, but I didn't know there was a form like this. I mean, I don't know
That's
how
the
you found
one
it. But
form. Yep.
real quick, it says rental agreement. So I should present my rental agreement. I should,
Check, no, just check the boxes. Don't present it with that. You're gonna present it later.
later. Okay.
That's just gonna give you your day in court. That's what that does.
Okay. And that would
Once
be in
you
the
file
UD.
that,
Mhm.
that's gonna then put you in the court. That's gonna give you your day in court. It's a right to possession.
Mhm. When you say file, you mean filing it
Once you give that to the sheriff at the sheriff's station, he's
right.
gonna stamp it. And then he will then say, bring this to the court in 2 days
Got it.
after he stamps it.
Got it. And with into the case that you did the same case, right? Just filing the
Well,
same case, right?
whatever case is going on, it's got a writ of
Got it.
possession.
Look, I appreciate it. Yeah. Okay. Awesome. Okay. And this is what they were looking for, but I didn't know there was a form like this. This is great. I was gonna file
Yeah.
a lien,
No, that's all arbitrary.
arbitrary. Okay. Okay. That's after the
Like I
fact,
said,
right?
there's only one remedy. Everything else is arbitrary.
Thank you. Thank you.
Yeah.
Well, Gavin, you took your time and spent it on me, and I really appreciate that.
Good. Now I'm so glad that we figured it out.
well, it's just I want to bring you good news as soon as I can do
You're
this.
gonna need to you're gonna need to show proof to the sheriff that you live there. You'll need to bring your ID with your address or bring a bill, like a PG&E bill or a utility bill with you.
Yep,
That's
that's
what you have
good.
to bring.
Okay.
Say, look,
I
this is proof to the sheriff. He's gonna say, I need proof that you live there. Here's proof, sir. Here's a bill in my name. Here's my ID in my name with the address.
okay.
Once he
Okay,
gets
that's great.
that, he'll sign off.
And then when I get to court, I would just do the same thing
One
that
thing at
Slim
a
did.
time.
Okay,
One
got
thing
it.
at a time.
Got it. Okay. I don't want to keep you. Really appreciate it.
All right, you got it. I'm gonna end the meeting, everybody. That was a great long meeting, and I'm gonna get this out there for everybody. So thanks for
It's
staying on there. It
priceless.
looks like we still have some people staying on there, and we actually figured out the problem, to your the solution to your problem.
Thank you. It's priceless.
I can't
Priceless.
wait to hear from Salam. He'll laugh about what this one was. He's gonna have a chuckle when he tells you the story of this one.
Oh man, I can't wait. I can't wait.
All
I want to
right.
laugh with. I want to laugh with you. Thank you.
You'll laugh. He'll laugh big time when you really tell what happened with Judge McGuire.
Good night,
All
Gabe.
right. Good job, guys. See you, Modi. Good night, everybody. Good night,
Good luck to y'all.
Richard, Modi, Ramon. Peace.